the Rehnquist Center's annual Supreme Court review. I'm very pleased to see so many of you here today. Looking forward to a great conversation. The Rehnquist Center is a non-partisan institution established to honor the legacy of Chief Justice William Rehnquist by encouraging public understanding of the constitutional structures of government that were so central to his jurisprudence. We're fortunate enough to have one of the Chief's former law clerks, Brett Dunkelman, here with us today, a supporter of the center, and welcome, Brett, and welcome to all of you. This year, as in years past, we have gathered three extraordinary panelists to discuss the most important decisions of the recently completed Supreme Court term. Our panel will conclude with a session devoted to the legacy of Associate Justice Anthony M. Kennedy, who announced his retirement in June of 2018 after 30 years of service on the court, the last 12 of which he spent as the court's median or swing justice, a very important role on the court, which we'll talk more about later this afternoon. First, I need to introduce myself and our panelists. My name is Andrew Coan. I am a professor of law here at the James E. Rogers College of Law and associate director of the Rehnquist Center. I will be your moderator this afternoon. Our first panelist is the incomparable Toni Massaro, Dean Emerita of the College of Law, Regents Professor, this is a mouthful, Milton Repeat Chair in Constitutional Law, an 8-time winner of the college's Teacher of the Year Award. How would you like to be the one teaching the other section of first year constitutional law? Responsibility falls to me. Our second panelist is Franita Tolson, professor of law at the University of Southern California's Gill School of Law, and one of the nation's leading experts on election law and constitutional law more generally. Her new book on the 14th Amendment, titled A Promise Unfulfilled, is forthcoming with Cambridge University Press. Our third and final panelist, actually seated in the middle of today's panel up here, is Chief Judge Peter Eckerstrom of the Arizona Court of Appeals, a longtime friend of the College of Law. Judge Eckerstrom is a graduate of Stanford Law School. He spent most of his career as a public defender and a criminal defense attorney before being appointed to the Court of Appeals in 2003, where he has served as an extraordinarily thoughtful judge. And Chief Judge Eckerstrom also has a new article forthcoming in the University of Pennsylvania Journal of Constitutional Law, so we can add scholar to the title of judge. We're very, very pleased to have him here with us this afternoon, and thanks to all of you for being here. Before we dive into our first case, I want to provide a little bit of background. Every year, the Supreme Court opens its annual term on October 1st and issues its final opinions at the end of June. This past year featured an unusual number of blockbuster rulings. It was also noteworthy for being the first full term of Associate Justice Neil Gorsuch, appointed by President Trump to replace Justice Scalia in the spring of 2017, and for being the final term of Justice Anthony Kennedy, as I've already mentioned. Together, these two changes in the membership of the court are likely to shape the course of the court as an institution for years and perhaps for decades to come. That will be a running theme, I'm sure, of our discussion here this afternoon. Without further ado, let's turn to our first case. Masterpiece Cakeshop, LLC versus Colorado Civil Rights Commission. For this case, and for each of our remaining sessions, I will begin by offering a 5 to 10 minute summary of the facts and the legal question before the court. I will then pose a series of questions to our panelists. Typically, I will direct each question to a specific panelist and then offer the other panelists an opportunity to comment. Any remaining time will be devoted to Q&A. One of our excellent students here at the College of Law, Francie Luna, up here in the front, has volunteered to take a microphone around the room for those of you with questions. If you have a question, please just raise your hand. We'd ask you to use the microphone because this afternoon's event is being recorded. Each session will last for 45 minutes. And there will be followed by a short break, so don't worry if you cannot stay after the afternoon's entire program. If you need to enter or leave during a session, please try to open and shut the door quietly. Our first case for today began in the summer of 2012 when Charlie Craig and Dave Mullins walked into Masterpiece Cakeshop in Lakewood, Colorado, just outside of Denver. Craig and Mullins were engaged to be married and wished to purchase a cake for their wedding reception. Because Colorado did not permit same-sex marriage at the time, this is 2 years before the Supreme Court recognized the constitutional right to same-sex marriage, 3 years before the Supreme Court recognized the constitutional right to same-sex marriage in the Obergefell case, the couple planned to be legally married in Massachusetts and to host a reception for their family and friends back home in Denver. When Craig and Mullins told the owner of Masterpiece Cakeshop, Jack Phillips, that they wished to purchase a cake for, quote, our wedding, he explained that he did not make cakes for same-sex weddings. To quote Phillips verbatim, "I'll make you birthday cakes, shower cakes, sell you cookies and brownies. I just don't make cakes for same-sex weddings." After a silence that Craig and Mullins described as mortifying, they left. Later, they would recall the moment as deeply painful. As Craig summed it up, "We were publicly humiliated for who we were." The following day, Craig's mother, who had accompanied the couple to the cake shop, called Phillips to ask why he had refused to serve her son. Phillips explained that he does not create cakes for same-sex weddings because of his religious opposition to same-sex marriage. He later explained his belief that to create a wedding cake, which he regards as a form of artistic expression, for an event that celebrates something that directly goes against the teachings of the Bible would have been a personal endorsement and participation in the ceremony and the relationship that they were entering into. In September 2012, Craig and Mullins filed a discrimination complaint against Masterpiece Cakeshop and Phillips. The complaint alleged that Craig and Mullins had been denied full and equal service at the bakery because of their sexual orientation in violation of the Colorado Anti-Discrimination Act. Phillips did not contest this allegation, but raised two constitutional defenses. First, he argued that the state could not compel him to bake a cake for a same-sex wedding without violating his First Amendment right to freedom of speech. Second, he argued that a decision for Craig and Mullins would violate his First Amendment right to the free exercise of religion. The nub of his first argument was that a wedding cake is not an ordinary article of commerce, but rather a form of constitutionally protected artistic expression. The nub of the second claim was that Mr. Phillips's right to freely exercise his religion in a commercial setting trumped Colorado's power to guarantee equal access to public accommodations to all of its citizens. After a formal hearing before an administrative law judge, the Colorado Civil Rights Commission rejected both of Phillips's constitutional arguments and ordered him to cease and desist discriminating against same-sex couples. In reaching this decision, the Commission relied heavily on the U.S. Supreme Court's 1990 decision in Employment Division versus Smith, known to some of you law students as the Peyote case, in which the court held that neutral laws of general applicability do not violate the free exercise of religion, even if their application imposes a substantial burden on some religious believers. As the Commission saw it, the Colorado Anti-Discrimination Act applied to all operators of businesses open to the public, and was not motivated by any special hostility to religion. Under Smith, it was therefore constitutional. Phillips appealed, but the Colorado Court of Appeals affirmed the Commission's decision, and the Colorado Supreme Court denied review. The United States Supreme Court then granted Phillips' petition for certiorari. This case represents the culmination of a years-long battle by religious conservatives against anti-discrimination protections for gays and lesbians that dates back at least to the Supreme Court's 2012 decision invalidating the Federal Defense of Marriage Act, and arguably back to Barry Goldwater's campaign against the Civil Rights Act of 1964. It attracted dozens of amicus briefs on both sides from government officials, academics, religious and civic organizations. Only a tiny fraction of Supreme Court cases attract this kind of legal firepower. On June 4th, 2018, the court decided the case 7-2 in favor of Jack Phillips and Masterpiece Cakeshop. But it did not hold that wedding cakes are protected expression, nor did it hold that anti-discrimination laws must always give way when they conflict with sincerely held religious beliefs. Instead, the court found that the Colorado Civil Rights Commission's application of the law to Jack Phillips was tainted by hostility to religion. And even a facially neutral law, like the Colorado Anti-Discrimination Act, that applies to all public accommodations generally, still violates the free exercise clause if it is motivated by an anti-religious purpose. Why did the court believe that the commission was motivated by hostility to religion? It gave two reasons. First, one member of the commission stated during the commission's public deliberations that, quote, religion has been used to justify all kinds of discrimination throughout history, and to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others. Second, and perhaps more importantly, the commission treated Phillips differently than it treated other bakers who refused to bake cakes with anti-gay marriage messages. For these reasons, the court concluded that, quote, the commission's treatment of Phillips's case violated the state's duty under the First Amendment not to base laws or regulations on hostility to a religion or religious viewpoint. At the same time, Justice Kennedy's majority opinion quite strongly endorses the power of states to enforce generally applicable anti-discrimination laws. I quote again from the majority opinion. Our society has come to recognize that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. For that reason, the laws and the Constitution can, and in some instances must, protect them in the exercise of their civil rights. The exercise of their freedom on terms equal to others must be given great weight and respect by the courts. While religious and philosophical objections to same-sex relationships are protected, it is a general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. Recall that this language, this opinion, was joined by 7 of the 9 justices. Only Justices Ginsburg and Sotomayor dissented, but Justices Kagan and Gorsuch wrote important and telling concurrences, which read the majority opinion very differently. On Justice Kagan's reading, states are never required to exempt religious objectors from the reach of anti-discrimination law, nor are they under any obligation to extend the protection of anti-discrimination law equally to the purveyors of anti-gay messages. Under Justice Gorsuch's reading of the majority, any state that does not exempt religious objectors or extend the protection of anti-discrimination law equally to religiously motivated anti-gay messages can only be motivated by hostility to religion and therefore acts unconstitutionally. Which of these readings is correct? Perhaps more important, which of them is most likely to win the support of 5 justices going forward? Before we get to this ultimate question, I'd like to start with a more basic one. Let's turn to our panelists. Professor Massaro, Colorado punished Mr. Phillips for discriminating against a same-sex couple while permitting other bakers to discriminate against anti-gay messages. Does that demonstrate the state's hostility to Mr. Phillips's religious beliefs? Alternatively, does it violate his freedom of speech by discriminating against his religious viewpoint?
Everything about this case was hard, I think. Everything about this case was hard because there are so many moves. If you frame it as one, then the doctrine consequences flow from it. And this is one of them where it depends on which move you're willing to make. There's no comparison, would say Justice Kagan, between what would have been allowed by the Colorado Commission and what was disallowed by the Colorado Commission, if you take the anti-religious animus out of it. How does that work? Well, the individuals who were refusing to provide to anybody specific language that said on one side or the other of the controversy, gay is bad, gay is good. Just to give you an example, for them to say that such individuals are not violating the Colorado law because they're treating everybody the same. See, nobody. They're not going to sell a cake to anybody that has that language. And she says that's one set of cases. What's different here is Mr. Phillips simply says before the cake is designed, or anything else. He says, I will not make a cake for you for this ceremony. And so the first frame of it would be to say that they were denied service because of who they were, versus somebody being denied service because of what they want to say. And so in that sense, if you buy the distinction that Justice Kagan is making, the fact that they would have protected the speech of the baker who doesn't want to create a cake with specific language on it, but not protect the conduct of creating the cake for these customers and not others, based simply on the fact that this was a same-sex couple, would enable you to distinguish the two cases.
Would this case have been any different in your view if the negotiations between Mr. Craig and Mr. Mullins and Mr. Phillips had advanced further, and Mr. Phillips had only refused to bake the cake when the couple had asked him to include a celebratory message on the top of the cake?
That's another reason why it's so hard. They sat on this one for a really long time. And so, like, what are they going to do? What are they going to do? We talked about it in class, and said they're going to find a way to rule for this cake maker. The question of how they're going to get there. And so they did. But you change the facts. I mean, it's a very unsatisfying opinion for figuring out what comes next, because if you change the facts and now change the composition of the court, and take Justice Kennedy off of it, I think it's entirely possible that it would come out differently.
Judge Eckerstrom, do you have anything to add?
You know, there's another way of arguably distinguishing the two scenarios, Phillips' scenario and the cake makers who refused to put what they viewed as offensive language on cakes. And that is that the argument is made that the cake makers who were supposed to put offensive language would have applied that to everybody. So similarly, had they been asked to make a cake that was pro-gay marriage, but had hostile language to people who might have had a different view. So I think the public accommodations laws really says that if you're going to provide a particular service, you have to provide it to everybody. But if one of the services, the latter cake makers, not Mr. Phillips, I don't know how we refer to them as a group, but the progressive cake makers, we can call them. If they were, as to everybody, a service they were not providing is a service of providing what you might characterize as offensive language on their cakes, then that could be viewed as not a violation in any way of the Colorado Public Accommodations Law from that perspective as well. So that's another one of the lenses by which it could be looked through, and another one of the reasons I think Professor Massaro would say it's a difficult case to come to any conclusions about. But I do think it's interesting that I guess I don't know how the majority breaks down on it, but the majority decision is hostile to that notion. In other words, its characterization of what the progressive cake makers did is that it's identical to Mr. Phillips' Act. So those distinctions were rejected by the majority of the court, or before Judge plurality became the majority opinion of the other concurring ones came.
Couldn't Mr. Phillips argue that he, just like the progressive bakers, would refuse to sell this cake to any customers? He's not willing to sell a cake celebrating a same-sex marriage to a same-sex couple. He's not willing to celebrate a cake celebrating same-sex marriage to an opposite-sex couple or friends of the same-sex couple. He's simply unwilling to sell any cakes with this particular message. Is that any different than what the progressive bakers did here and were allowed to do by the Colorado State Civil Rights Commission? Maybe I'll direct this question to Professor Tolson.
What are progressive bakers again?
That's an important question in this case. Several other bakers in the state of Colorado have been asked by religious opponents of same-sex marriage to bake cakes with anti-same-sex marriage messages on them to set up this case.
I got it. Okay.
And they refused, and the Colorado State Civil Rights Commission said, that's fine. Our state anti-discrimination law doesn't obligate you to bake those cakes, but it does obligate Mr. Phillips to bake this cake celebrating the same-sex marriage for Mr. Craig and Mr. Mullins.
Right. So the question is interesting in part because, and not maybe on the sort of fringe with this, but it's hard to see this case as precedent. And it goes to some of the points that were raised earlier, because if you change the facts just a little bit, I think that you end up with a different outcome. But I also think that the way that the opinion was written up in this way is how we got to 7-2. For example, I think that at the end of the day, Justice Thomas might have the opinion that that his approach might actually be the one that the court takes in the end once the composition of the court changes. And let me explain what I mean by that. As you pointed out in your description of the case, the court avoided a lot of the hard questions that came up about whether or not the baking of a cake is an expressive act. And I think that Justice Thomas makes the point that, and he cites to an earlier case called Hurley, where it had to do with parade organizers, and they excluded a LGBT group from the parade. The court held that the parade was the form of expression. And it seems to me that to the extent that this case works its way back up to the court, and it may, right? Because it's so fact heavy, all this requires is for another gay couple to go into Jack Phillips' cake shop and try to buy a cake, right? And then they filed charges against him, and we're back where we started. I think at the end of the day, the court will sort of line up behind this idea that Jack Phillips is a creative force, and what he does is expressive, and that this is a free speech violation. I hope I'm not getting ahead, but it's really hard to, at least in my view, talk about how different facts change the outcome, because I just think it's hard to see this case as precedent because it's so fact dependent. And I think any little change could have dictated a different outcome here. I think this is why the court focuses on the comments of the commission, because it was the comments that 7 justices could arguably get behind. But ultimately, when this case works its way back up, the court is going to have to make some hard decisions about whether or not baking a cake is actually speech. And that issue, they could skirt it because it wasn't squarely in front of them. He refused to make any cake. It wasn't a cake that had a message on it. So when it goes back up, I'm sure whoever the same-sex couple will be the next time will ask him to make a cake saying X, Y, and Z in order to tee up that question.
You know, what stands out in this is how we talk about all the issues that aren't resolved here, and that we would speculate about what the court's result would be as to all the different nuances that are presented, and all those aspects are theoretically presented in some respect by the particular facts that were before the court. But this is a court that seems to be energetically exerting itself not to take a position on this case. So yeah, it isn't just one side of the court or the other that wants to kick it back for new fact findings in front of the Colorado Commission, or kick it back to that level. And so this sort of resonates in the courts, and perhaps this has become more acute over time, and that might be a topic we discuss in our 4th session. But the court's self-awareness of the extent to which it is being perceived as arguably an arbiter of politically partisan disputes, and how it's being perceived perhaps as a partisan organization itself, as a partisan institution itself. And I know as an institution it is very eager not to be perceived that way. So you could arguably see Justice Kennedy's opinion in terms of his own legacy as struggling with the fact, the language that you articulated before that acknowledges the tradition of public accommodations laws and the discrimination against our gay citizenry would certainly not be an acceptable thing going forward in the context of that, coupled with the aggressiveness with which he attacks the Commission's statements that seem to be anti-religion. Is, you could argue, he's sort of playing to both audiences in that opinion, and I think the rest of the court kind of likes that compromise for now. And so you can view this as a court trying to, you can view this as Justice Kennedy punting to whoever his successor is going to be, because theoretically he had an idea he might be retiring at the time this was issued and generated. But also, the court is an institution trying to avoid a hugely partisan dispute. I mean, because this particular bake shop case was being discussed in the public arena long before it ever got to the Supreme Court, right? I mean, I remember this was on the news when it happened, long before it went to the Supreme Court. So this was set up to be a resolution of what was an extremely partisan political dispute.
can I piggyback on that really quick?
Absolutely.
And I think that's a really important point because one of the things that sort of baffled me about this case is that the court has been willing to be an arbiter in cultural disputes, right? It's very easy to think about this as cultural as well as partisan. And in my mind, it's more cultural than partisan. At least not partisan in the same way as like partisan gerrymandering or issues that squarely fall within a political realm where a court might be reluctant to weigh in. This is a cultural issue to some extent where the court has historically been willing to kind of weigh in on whether or not really a moral view has any weight. We saw it in the abortion cases. You see it in, even with same-sex marriage, there's a cultural dimension to it, right? So it seems odd to me that the court would sort of take this middle path, especially Justice Kennedy. I think the judge is absolutely correct that he had to have some sense that he was retiring at this point. And if you read the decision and the fact that you have these two concurrences that interpret the majority's decision completely differently, shows that Justice Kennedy has left the door open for even more conservative appointee to come in and sort of dismantle what he's done here. And that just seems odd to me. And so I don't get the reluctance to confront head on the issues presented in this case, and it just seems really odd that they put so much weight on the Commission's comments.
Well, let me follow up. Did you want to chime in here, Professor Massaro?
You know, you started with, well, then it goes into the speech box. And if we get to that, even if it goes into the speech box, then the question is, so what? It just should trigger a compelling, does the government have a compelling reason to prevent a proprietor who opens up him or herself, not in private worship, but in a place of public accommodation, to certain restrictions that wouldn't obtain elsewhere. Belief is still intact, but conduct associated with the belief isn't. So that question is, you know, not resolved, and I think the court's really apprehensive about getting to it. Why? Well, Kennedy himself wanted to reassure people that when he's making this big decision in a series of them with respect to LGBTQ rights, that he still respected dissent. And respected that people in good faith can disagree on this, right? And to that extent, I think that it's completely consistent with Anthony Kennedy's MO to be genuinely torn in this case, and he knows he's going to be the dispositive vote, and so that's operating here, wholly independent of the other constraint the judge has mentioned about the political theater. This is red meat for the right, and hair on fire for the left, and you know, it's just a cake, and it's blah, blah, blah. I think it's just Kennedy, and his soul's divided here. He wants, you know, can't we all just get along? But if you dial it back, I want to say something about, you either think that this is equivalent to race discrimination, or you don't. Because the religious communities themselves are saying, you know, this isn't like those cases in which the issue's largely, though painfully, resolved. Ollie's Barbecue is a case in which they refused to seat African-American patrons in the front. They were more than willing to serve the African-American patrons barbecue in the back. Right? So this notion of public access and dignity, at some point your equality runs into freedom of association and private rights, and you have to choose. And it's not an easy decision. And with race, this is what Professor Tolson's saying, you know, the decision has been made. And I think that the difference about LGBTQ rights, first people think that this is sudden. Oh, it just happened. Let me tell you, there's nothing sudden about this. There may have been a cascade, but it's been something that's been going on for decades. But let me, if I can, and then I'll hush. The life story of a right. It begins with what Dan Coan calls thin walls liberalism. I'll give you the right. I'm not going to arrest you, but just stay in your apartment and don't make so much noise, right? And so there's an announcement of we're not going to criminalize same-sex conduct in the privacy of your own home, consenting, etc. That's stage one. And then it moves, and it goes from a thin liberalism right to a thicker right. And the thicker right includes all the way up to Obergefell something much more challenging, which is you have the right to exist and to enjoy and participate in something freighted with a tremendous religious and cultural meaning, right? And he did it. You know, he did it, but the implications of it are not, you know, it's just like with the civil rights movement, there was resistance from all quarters, including religious quarters, with respect to the right. And so I think we're at a thin right where the court announces a thick right in Obergefell, same-sex marriage, but we're not all on board. And I think Kennedy is responding to this and thinking maybe we need more breathing room. Maybe we need more religious-based or conscious-based refusal to cooperate because the war is over. You know, that ship has sailed. Now it's a question of individual opportunities to dissent. But if you put it in the historical frame, there's an answer, and it is you bake the cake. It's the cost of running a business. Unless, and this is why it's harder than that, are you going to make me do your portrait? Are you going to make, then it becomes more and more a question of compelled speech. And then you have a court that is really into free speech. And so the next time it comes up, I think that if it's put in the speech frame, you have a lot of ways in which you can go after this to protect the individual, not just religion. But the thin right to thick right, it's a big deal. And I think the gay couples are saying, this is the thick right. You can't possibly deny me that cake just because I said I'm getting married. And the baker says, this is you can't possibly burden my deeply, most core held conviction. I'll sell you anything else in the store, right? Anything else in the store. You want some barbecue? Come on back.
So I agree 100%, and I think that's why I'm so profoundly disappointed in Justice Kennedy, because if you look at race discrimination, in the 1960s, Congress realized that you had to attack it on all fronts, right? This is why we had a Civil Rights Act in 57, 64, and then a Voting Rights Act in 65. And the Civil Rights Act in particular was important because it attacked private discrimination, which is something that Congress had tried to do before in the 1870s, and the court reversed them. And that's how we end up with the state action doctrine. But the point is, Kennedy failed to follow through, right? He did. You can look at Obergefell as establishing a thick right, but he didn't see it through, and that's why I don't understand. To the extent that we are committed, and with Obergefell, there does seem to be a level of commitment to the idea that LGBT. I know I just offended like 20 people in the room. Gay and lesbian individuals they're part of our society, they matter, and they should be properly incorporated. You have to see it through, just like we deal with race discrimination, regardless if you agree or disagree ultimately, because you're right, in the 1960s there were some individuals who were opposed to integration on religious grounds. And as a society, we decided that we should not get that way, right? But admittedly, I don't want to be so naive here. We do have a Supreme Court that is committed to a very broad view of the First Amendment. They're very protective of it. Some people would even say that it's been weaponized. So I don't mean to suggest that there aren't barriers to doing this. But at the same time, unless we had that level of commitment that we had on the race front, then I just feel like people are essentially saying, okay, they can get married, that's enough.
What's really interesting in this particular discussion is the NAACP wrote an amicus brief in Masterpiece Cake. And in that amicus brief, they highlighted the series of public accommodations cases after the Civil Rights Act that was passed in 1964. And from the standpoint of whether having a particular religious belief would entitle you to discriminate in violation of statute protecting against discrimination, that is settled law, right? That is not that, and that should be settled law now. So to the extent you treat the gay and lesbian community identically to discrimination against minorities, the Supreme Court would have had to overturn probably 4 or 5 of its own Supreme Court cases to hold otherwise. Some, like the barbecue case Professor Massaro talked about, almost identically analogous in that area. So one of the interesting questions in my view is that we know that the law might be different in the area of the First Amendment, and I would defer to the two professors here on the nuances of what First Amendment law, how it might be different than freedom of religion law. But of course, both the First Amendment and the freedom of religion are in the same, free speech and First Amendment are in the same amendment. And I'd be curious about why you would have a more protective standard for free speech than you would have for exercise of religion. And I'm sure that resonates in the areas of law and would be a different vector, as Professor Massaro would put it. But that's a question I have that I'd be curious about. And if they're not different and you were to treat them differently, we have settled law on all fronts, in my view.
Two things. One, I want to follow up. The religious community, I think of growing up during the Civil Rights Movement and, Father Grappi in Milwaukee. I mean, the church, we are saying, yes, there was religious resistance to integration. There was also fantastic religious leadership in the front line of the Civil Rights Movement of that era, the Catholic Church, the Baptist Church, the African American church community. So I think that when I don't think we have comparable united religious leadership on both sides of this issue, and that may have caused Kennedy some heartburn. I'm not sure. On the free speech, we just talked about this morning in class. There are lots of reasons why speech is treated differently, including that speech isn't conduct. And our tolerance for conduct and religious, when it veers into free exercise, we're talking conduct. As we said, even John Stuart Mill, the libertarian of the 19th century, said, your right to swing your fist ends with my nose, right? But if you say, I'd love to punch you in the nose, the speech is thought to, by definition, have less of a harmful effect, and there are many, many other reasons why speech might be tolerated in contexts in which our conduct, however motivated by deeply held conscience, including religious conscience, would not be. And that's back to the Coan case, if we get back to it.
Well, you're all making my job very easy here. This panel doesn't really require a moderator. But let me come back to one of the central legal and doctrinal issues in the case, which is the significance of the remarks of the Colorado Civil Rights Commissioners at the hearing before the commission. Professor Tolson has already suggested, I think implicitly, that those remarks were a kind of make-way, or maybe just an easy way for 7 justices to reach an agreement in a case that would otherwise be extremely hard. I'm wondering what you think the significance of remarks like that ought to be more generally, outside the highly particular and unusual circumstances of this case and the sort of historical development of the membership of the Supreme Court. Was the court right to consider those remarks? And did those remarks demonstrate the Commission's hostility to Mr. Phillips's religious beliefs? I'll direct this to Judge Eckerstrom.
I think the court was right to consider them, and obviously had to put its mind around them because they were a part of the claims before it. But so at our Court of Appeals, we decide a lot of challenges to what regulatory agencies do. And we see different commissioners of different agencies say things that create the lawsuit in the view of the litigants. And I'm just talking about this in a general sense of how you look at commissions and agencies and regulatory groups when you review them from a judicial standpoint. And usual standards review are deferential and review a particular body's actions also with an eye towards did the bad remark actually make a difference in the outcome of the case. And from that standpoint, it feels odd to me that the remarks of one of the commissioners would be given that much weight when, from the standpoint of what usual standards of judicial review are for governmental agencies in that context. Now, there really isn't any perspective of that right given by any of the opinions in this, so maybe the United States Supreme Court is a different body, but it does seem like it almost wants to reach out for that because it is the type of thing that you could plausibly see a Supreme Court opinion really just brushing aside and saying, it's regrettable, we don't like the fact that it happened, it raises uneasy questions, but the fact of the matter is this was only one of the commissioners, and we can look through to the facts of the case and see that from the standpoint of what happened here, this clearly violates what was before them, and therefore we're not going to reverse the Colorado Commission's ruling. So I thought it was interesting. It was not surprising to me that they addressed the problem. It was interesting to me that they moved it to the center of their analysis and was arguably one of the dispositive factors. I don't think they had to do that, I guess would be the way I would put that. Now the second tier of that, the analysis of whether in application the commission was applying the law unequally. Now, I think that's the type of thing that almost any court, and the Supreme Court probably had to take extremely seriously and analyze. But I do think just the particular remarks, I think someone earlier said that was giving some red meat to a particular faction in this, to be a diplomatic court. And frankly, it seems like it got more weight than you would expect usually in the context of that type of review of a commission's analysis.
Let me put just one more question to the panel, because I do want to save time for some questions from the audience. And what I'd actually like to do is to convert one of the questions that I had in mind into a statement, since it's already been discussed rather exhaustively. But I think the core issue at the heart of this case is whether the conflict between religious liberty and civil rights is real or artificial, or how deep is that conflict. And I think every one of the panelists this afternoon here is already on record as saying, yes, there's a real conflict. No anti-discrimination law and religious liberty cannot peaceably coexist, and religious objectors just have to deal with it. I want to make sure, though, that I'm understanding all of you correctly. So let me just ask, let's go down the line here, starting with Professor Tolson. Do I understand your views correctly, and would you like to say anything else in defense of that very quick reformulation of them?
You don't have to ask me. No, I was very clear that that's my view. I think that, and in fact, one of the commissioners had made a comment about, with respect to Jack Phillips, and he said that's the cost of doing business in Colorado, or something to that extent. And it made me think, because one of the things I realized about rights is that you do have a right to do things and believe things, and you have a right to sort of be this person you want to be at home. Right? If Jack Phillips wants to operate in that space, then he had to, on some level, accept that some of his rights would be burdened. And I think as a society, we all agree to that to some extent, because none of us get our ideal society. So yes, I'm not denying that the conflict between civil rights and religious liberty, that is real, and that is something that will continue moving forward. But at the end of the day, sometimes society as a whole, when we agree to participate in this thing, we have to give up some of our freedoms. And so I do view the case in that way.
Judge Eckerstrom.
Yeah, I obviously a case like this involves a direct conflict in tension between, arguably between 14th Amendment principles and First Amendment principles. For a pluralistic society like ours, involves real hard thinking about how you put a society together. And interestingly enough, it's hard thinking that the Supreme Court has to sometimes resolve as a institution that isn't our public policy making institution generally. So it fundamentally goes to the institutional role of the courts. Here we have, of course, a statute generated by a public accommodation statute generated by the state of Colorado that's being enforced. So we have a legislative branch perspective on it. But certainly we have the Supreme Court in enforcing the First Amendment and the 14th Amendment is going to have to make some calls too that aren't always going to be informed by legislatures. And that's of course because our constitutional amendments and the Bill of Rights specifically, including the 14th, which isn't of course in the Bill, not in the Bill of Rights, but they're designed to be the rights that majoritarian legislatures cannot take away. That the government that presumably represents the majority aren't entitled to take away, right? And so you have a conflict here between a majoritarian endorsement of one right, which is arguably an application of the 14th Amendment by the Colorado legislature, at odds with a minority's or a group that lost at that legislative tribunal, which is those people in Colorado who believe it violates their religion and don't believe gay people should be allowed to get married. Those things are in conflict, right? And so the Supreme Court actually cannot avoid taking a position because it has a role to scrutinize legislation that mediates constitutional rights, because those rights, of course, cannot be fully mediated by majoritarian institutions. And that's an evasive answer because it doesn't give us actual answers as to the actual result in this. But I think that is the tension that this case presents that is always going to be a recurring one in terms of speaking about the institutional role of the judicial branch and the Supreme Court specifically.
Professor Massaro.
We have to choose. Charlie Black wrote in the 1960s already, said when we chase the sort of the demon of discrimination down to its last layer, and he was talking about places of private association, that it takes a, sort of an act of, it's a daring act to say not even there, not even in those last private spaces. But let me reverse. Put on other hats. I mean, free exercise of religion under the peyote test is kind of thin gruel. That's part of, I think, Justice Scalia's legacy that may be about to change. I think that the current court might be interested in invigorating free exercise claims, which once would have been something both left and right would agree on. And so I have tremendous respect for what Mr. Phillips is saying and doing and believing. And most people who are parts of majority religions, even if the religion people are in the minority, your conduct is already accommodated, right? Yeah, all the ways in which you tend to worship if you're in the majority, the calendar takes you into account, the costuming takes you into account, all these things take you into account. And so within the universe of religious peoples, I think there's an uneven, disparate impact on those whose conduct departs from the majority of religious people's conduct too. So it's an inevitable, inescapable pickle for a democracy, a liberal democracy like ours. And all I'm saying is, if you buy the analogy to race, that tough question has been answered. And I just don't think that analogy has been bought. There's an older case called CLS versus Martinez, in which the court and the people arguing on behalf of the religious people went out of their way to say, we're not talking about race discrimination. Right? Discuss amongst yourselves.
Okay, I think we have time for a single question from the audience. I really want to keep us running on time here this afternoon. In the back.
Thank you.
But please wait for the microphone if you would. Thank you.
In 1791, our Bill of Rights became part of our Constitution, in part, as I think some of the panel members have stated, to protect the rights and liberty of minorities against majoritarian inappropriate rule. And here's my concern. I think that the religious clauses of the First Amendment, including the right to assemble, which includes the right to be part of a group that you feel comfortable in belonging to, coupled with the 14th Amendment Equal Protection Clause that says First Amendment rights in part are applied to the states via the Due Process Clause, etc., that protects minorities equally with majoritarian rights. Let's assume this hypothetical. Jerry Falwell Jr. moves from Virginia to Denver, Colorado, and is a pastor of an evangelical conservative church whose members all adopt a creed that no person within their congregation shall be a part of that congregation who is gay or who believes in gay rights.
I'm sorry, could I ask you to wrap up very quickly because we are really actually already out of time. I apologize.
If that church congregation through the pastor decides to hire a gay activist or decides to deny employment of a gay activist for a janitorial position, is it all of your positions that that congregation does not have a right to decide who is going to be employed by that church and paid by church members? Thank you.
Very quickly, Justice Massaro.
Well, you have three layers to your point. First of all, the church has the right, has rights in this, that it wouldn't have if they were holding themselves out as a place of public accommodation. Now, you've complicated it because they're functioning in a gray area where they're not just having worship services, but they're actually employing people within it. There's a case that involved, though it's got another curveball, the ministerial exception, where a woman worked for a church and wanted to invoke the right against discrimination on the basis of disability. And it's not on all fours, but in that case the court concluded that her right to complain about disability was subordinated to the church's right to control people within the umbrella of the ministerial exception. On the employment side, though, the law has historically, and to this day, already built in a fair amount of accommodation for religious institutions with respect to employment policies that have these kinds of effects. So I think the answer, and of course discrimination on the basis of sexual orientation is not a violation of law everywhere. Unless it's the government that's engaging in it, you have a constitutional right. Now that may sound like a mess, but that's common law, and the answer is, I don't know.
Well, on that reassuring note, I have to conclude this first panel. We will reconvene at let's say 1:56 and begin our second panel then. Thank you very much. Just a couple of minutes to get in and out if you need to.
People
conversation. The subject of our next session is the case of Gill versus Whitford. This case arises from my home state of Wisconsin, and is one to which I have an unusually personal connection. The plaintiff is my former colleague and close friend, Bill Whitford, an emeritus professor at the University of Wisconsin Law School. 5 or 6 years ago, he pitched me an early version of this lawsuit over a beer at the fabled Union Terrace in Madison. I told him it was a surefire loser. Characteristically, Bill persisted. And a couple of years later, he connected with a smarter young law professor than me at the University of Chicago named Nicholas Stephanopoulos, who had written a major new article on partisan gerrymandering. Together, Bill and Nick would ride that article and the novel theory that it advanced all the way to the United States Supreme Court. But I'm getting a little ahead of myself here. The story of this case really starts back in 2010, when Wisconsin's Republican legislature last redrew the state's legislative districts. The law passed to do so, known as Act 43, was clearly intended to entrench Republican control. That's not just an inference. There are public documents which clearly express the intent of the Republican legislature to entrench its control. And the Republican majority utilized a variety of outside consultants and sophisticated computer modeling tools to achieve this end. The practice of drawing electoral maps to provide built-in and insurmountable advantage to the incumbent party is known as partisan gerrymandering. Act 43 was an exceptionally effective example of this increasingly pervasive phenomenon. In 2012, Wisconsin Democrats received 51.4%, a majority of the statewide vote. It even passes in a purple state like Wisconsin for a large majority of the statewide vote. But that percentage translated into only 39 of 99 state assembly seats. This disparity remained durable through several election cycles, making the legislative map drawn by Act 43 the 5th most severe partisan gerrymander in the United States history, according to one expert analysis. By any fair measure, Wisconsin legislators had succeeded in choosing their voters rather than the other way around. The question for Wisconsin Democrats was how, if at all, to frame a legal challenge to this practice. The Supreme Court has long recognized that partisan gerrymanders are inconsistent with democratic principles and violate the Constitution, either the Equal Protection Clause of the 14th Amendment or the Freedom of Speech Clause of the First Amendment. But 5 justices have never been able to reach agreement on a standard for determining how much partisanship is too much. Some consideration of partisan advantage seems inevitable in the redistricting process, in any redistricting process which is conducted by elected legislators. So where is the constitutional line? And how can judges manageably draw it without themselves becoming entangled in the political thicket that Justice Felix Frankfurter memorably worried about in Baker versus Carr back in 1962. In a series of 3 inconclusive decisions between 1986 and 2006, one faction of the court consistently argued that partisan gerrymandering claims qualify always and across the board as what are called non-justiciable political questions. That is to say, questions that courts are not competent to answer because the Constitution supplies no judicially manageable standards for their adjudication. There's nothing in the First Amendment or the 14th Amendment that helps a court to decide how much partisanship in redistricting is too much. Another faction of the court has taken the diametrically opposite view that judicially manageable standards exist. They've identified such standards, or standards that they think qualify as judicially manageable, and that the court is fully competent to adjudicate partisan gerrymandering claims under these standards. But neither of these factions has ever controlled a majority of the Supreme Court. Instead, a third faction, which in recent years has consisted, like so many other factions on the court, solely of Justice Kennedy, has held the controlling middle ground, unwilling either to adjudicate partisan gerrymandering claims or to permanently close the door on such claims. This faction, Justice Kennedy, has basically said to plaintiffs, go back to the drawing board and bring us, or bring me, a clearer, better, more judicially administrable standard for deciding these cases. It was this invitation, Justice Kennedy's invitation, that inspired Bill Whitford, along with several like-minded plaintiffs and lawyers, to file suit challenging Wisconsin's electoral map in July of 2015. In Nick Stephanopoulos' article, they thought that they had found a standard which even Justice Kennedy might find sufficiently manageable. More pragmatically, they thought that the partisan tilt of the Wisconsin map was so severe that it could help to persuade Justice Kennedy that partisan gerrymandering was an urgent problem that only courts could plausibly hope to solve. In this quest, they would benefit from the special procedure for filing election law challenges in federal court. Instead of a single district court judge, Whitford's case would be decided by a 3-judge panel. From there, the case would proceed directly to the United States Supreme Court, which has mandatory jurisdiction over such cases. The Supreme Court still has tools it can use to avoid deciding cases that it doesn't want. But if the plaintiffs prevailed in this case before the 3-judge panel, if they persuaded the 3-judge panel to invalidate Wisconsin's legislative map as an unconstitutional partisan gerrymander, there was a very good chance that the Supreme Court would take the case. On November 11, 2016, the panel obliged them, and in a 2-1 decision, it decided for the plaintiffs. Wisconsin appealed to the Supreme Court, and argument was scheduled for the first week of October 2017. Whitford and Stephanopoulos would get their chance to persuade Justice Kennedy that they had discovered that holy grail of partisan gerrymandering litigation, a judicially manageable standard. By this point, you will have doubtless noticed that I have not said anything about what that standard was. If the Gill versus Whitford case had come out differently, if Whitford had decisively won or decisively lost, I would have no choice but to explain it to you. Fortunately for you and for me, although perhaps not for American democracy, I don't have to explain it because it played no role at all in the Supreme Court's decision. I will tell you that the standard is called the efficiency gap, and that it involves a comparison of what Stephanopoulos calls the wasted votes by each party, which is to say the votes for each party's candidates unnecessary to the outcome of the election. After that, it gets very technical, very fast. And if you want to know more, you can just Google Nick Stephanopoulos' article. He spells his last name the same way as George. Instead of deciding whether the efficiency cap was a judicially manageable standard, however, a unanimous Supreme Court decided against Whitford on what most non-lawyers would call a technicality. The court held that Whitford lacked what it calls standing to sue because he was not personally injured by the gerrymandered Wisconsin electoral map. He lived in a reliably Democratic district, so his preference for Democratic candidates, his ability to elect those candidates, was never negatively affected by the partisan gerrymander. And according to long-standing jurisdictional principles, only a plaintiff who is actually and personally injured by the government's action can bring suit to challenge its constitutionality. As a corollary of this rule, the Supreme Court further held that partisan gerrymandering plaintiffs could only ever have standing to challenge the boundaries of their own legislative districts, not a statewide electoral map, as the plaintiffs in the Whitford case had tried to do. Here's how the court summed it up. Quote, a plaintiff who complains of gerrymandering but who does not live in a gerrymandered district asserts only a generalized grievance against governmental conduct of which he or she does not approve. That has never been allowed. Now, I've said that most laypersons would consider this a technicality, but that is not how the Supreme Court talks about it. The court describes standing doctrine as a fundamental constitutional restraint on judicial power, The federal courts are not an all-purpose complaint bureau open to everyone who disagrees with government policy, or even to people who sincerely believe government policy to be illegal. As Chief Justice Marshall famously wrote in Marbury versus Madison, way back in 1803, the province of the courts is solely to decide the rights of individuals. Standing rules are, as the court explains them, meant to confine the courts to this role, this narrow role. Or so the court says. Many critics have argued that the court shamelessly manipulates standing doctrine to avoid cases that it finds inconvenient to decide for other reasons. Which is the case here? I'm going to punt that question to our panelists. But I'd like to start with a more basic question, which I want to direct to Professor Tolson, our resident election law expert. How serious a problem is partisan gerrymandering?
More serious now, given the level of technology. So partisan gerrymandering has always been a thing. It's not of recent vintage. But the technology is such that you can draw a plan that basically freezes a party's advantage in place for the duration of the decade. And that wasn't always true. And one might say, and one reason why this question is important is because it's impossible to come up with a standard that eliminates all partisan gerrymandering. And I don't think that most people understand that. So Democrats are clustered in cities, Republicans tend to be in more rural areas, and so just by definition, there are going to be some districts that are gerrymandered because of how people and where people live. But because of the technology, partisan gerrymandering has become a really, really bad problem, and that's why the Wisconsin gerrymander was so egregious, right? Because I think that it would have taken the Democrats, they would have had to win something like, I think 55% of the statewide vote or something in order to sort of overcome the Republican gerrymander. And even then, there are no guarantees. And that's because the technology is just so effective. But in terms of like the Constitution, one of the struggles is, and I want to go back to an opinion that came out of, I guess about 10 years ago. It's a case called Cox versus Larios. And it's a really interesting case because it's a case where the court is actually denying cert, and Justice Scalia wrote an opinion from the denial of cert that had to do with a gerrymander in Georgia. And Justice Scalia was one of the justices who believed that partisan gerrymandering should be non-justiciable. And the interesting thing about this decision is that he points out that eight of the justices then on the court believed that partisan gerrymandering was constitutional, right? And that they could not decide when partisan gerrymandering crossed the threshold into unconstitutionality. That really is the issue, right? The justices are not, and I feel comfortable even saying this with the current additions to the court, the justices are not of the opinion that all partisan gerrymandering is unconstitutional, because to some extent it's unavoidable. But what the justices are having difficulty with is finding that line in the sand where partisan gerrymandering has crossed from constitutional to unconstitutional. And that really is a problem we've been dealing with since Davis versus Van Damer, which was decided in 1986.
Judge Eckerstrom, Professor Massaro, would you have anything to add?
No, not for that. I'm not going to challenge the voting rights expert.
I think it's the worst problem of all. I think that it's because it creates structural deformities that affect everything else that comes out of it. And while I know that it's gotten worse with technology, I think of a conversation with Jim Colby, who was a former congressman from our area. And when he got out, he said, "I can't take it anymore." Why not? He was in a so-called Republican safe district, so packed versus cracked. And he said you have to outflank sort of the worst instincts of your own party, and you have no chance if you don't make it through the primary. Of course, you're not going to win, but it was just a Republican safe district, and the same applies to Democratic safe districts. And it's just, maybe that is the way it's supposed to work, but I don't think most of us believe that's the way it ought to work. So I think it's a very, 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 very serious indictment of the system that we currently have. And I think that in this case, Justice Kagan's opinion is particularly eloquent on that point of something has to happen, and who's going to do it. We're the only game in town, not because we're great, but because it's gotten that bad, and if we have any more erosion of confidence in institutions, what's going to happen? And so I think that it's more serious than Masterpiece Cakeshop, more serious than Trump versus Hawaii, as serious as that one was, and more serious than anything else that was on the docket for the court. And it's now graver because guess who's not there? Anthony Kennedy. So that's my 2 cents on this one.
And I guess to echo that, in that vein, I will say something about it. I agree with Professor Massaro that this might have been the most important and acute constitutional problem presented to the court this term, maybe perhaps far and away the most important one for the future of our institutions and our democracy. And I do have an opinion on whether it should be justiciable, and that is that there is no other institution that is capable of rectifying the problem. Usually in the area of claims that are viewed by the Supreme Court as non-justiciable, it's because there is a better governmental entity that's more competent in resolving the particular problem, right? So you'll find non-justiciability rulings in the area of separation of powers where the Supreme Court wants to stay out of it and they're going to let the other two branches sort it out amongst themselves through the politics and the voting booth, right? Here, the voting booth has been obstructed by the gerrymander itself. And so the legislative branch cannot be the body that sorts it out. And the only body left standing that could sort it out and could apply what the Supreme Court acknowledges as the rule of law. The Supreme Court acknowledges that a true partisan gerrymander violates the Constitution. It acknowledges that they happen. And the Supreme Court acknowledges both those things, right? But it doesn't acknowledge yet that it's the institution most capable of creating standards, and largely because it isn't sure it can create standards. But my response to that is the Supreme Court has to create standards in difficult situations all the time. They're accustomed as an institution to evaluating whether there's evidence of invidious discrimination. That's a customary finding in the context of the 14th Amendment. And so, in my view, a view that this is non-justiciable is puzzling. And also, I do think that the proposal that your friend makes is a non-political one. In other words, the Supreme Court would be searching for a standard that would be nonpartisan, where the Supreme Court couldn't be accused of being a partisan body in resolving it and deciding cases differently when there's a Republican gerrymander versus when there's a Democratic gerrymander. But it doesn't seem that coming to neutral statistical principles that would operate in every state are actually impossible or unworkable. And I do think the principle here is certainly a neutral one. It's not a political one. But my main feeling is you've got to come up with some standard. This is not one the Supreme Court can stand on the sidelines for, whatever that standard is.
I think that I agree with that, just in the sense of the Supreme Court has already opened the door for this, right? So in the 1960s, when the Supreme Court decided the one person, one vote cases, they kind of put themselves in the middle of this dispute. And so I don't think it's right to say that they get to decide to sit this one out. They've already decided that they have a role to play in policing these boundaries. That's the first thing. The second thing is that we argue a lot about the standard. And part of the problem is that we don't really have an objective basis for thinking about what a fair outcome is. I think that critique has sort of haunted any proposed standard, right? Because we don't know what a fair outcome would necessarily be. Although some have said that, you know, maybe it's about making every district competitive, which is not plausible in every situation. But generally speaking, there's an argument over what constitutes a fair outcome in these cases. But I don't think that should be a barrier to judicial intervention for a couple of reasons. So I think the judge makes a good point about some of the proposed standards out there. They do a better job than standards proposed in the past of trying to come to a neutral outcome, right? So the efficiency gap focuses on wasted votes. So votes that are in excess of the 50% plus one that a candidate needs to win. And trying to come up, it gives you a basic sense of when a plan is gerrymandered. And so I think that judges in their discretion can use that as one tool of many to try to decide whether or not a plan is problematic. But also the court has in the past used other doctrinal tools in order to address partisan gerrymanders. So in a case from about a decade ago, the court used Section 2 of the Voting Rights Act to address what was essentially a partisan gerrymander that happened to disadvantage Latino voters. The court has also used one person, one vote in the past to address partisan gerrymandering. So it's not as if the court is without tools to address these devices. And also the court hasn't necessarily been reluctant to use these tools to address these devices. So I agree, it seems weird for the court to sort of toss around the idea that they should take a step back.
So one common feature of many proposed tools is that they draw on social science, and one common feature of partisan gerrymandering claims is that plaintiffs frequently rely on social scientific evidence. At the oral argument in Gill versus Whitford, Chief Justice Roberts called such evidence gobbledygook. Is he right about that? And even if he's not, can we expect judges to analyze this kind of complex empirical research competently, and mightn't that be part of the reason that the court feels so reluctant to get involved here, that it feels incapable of doing so? I'll direct that right back to you, Professor Tolson.
That's what we have experts for. You have an expert teach you what they're doing. I didn't understand that, because it seems to me that the court is one where they take cases of all stripes, right? So they deal with IP and trademark, which are things I don't understand at all, right? But they do it. And a lot of those cases deal with hard science issues that they have to wrap their mind around. It might deal with technologies and various things that they may have no training in. So why is this that different from other areas where they have to tackle issues that they might not necessarily understand, but they have to rely on expert testimony? To me, this is no different.
Judge Eckerstrom.
Yeah, and just to echo the professor, there are a lot of different contexts, and specifically the 14th Amendment, where in the 14th Amendment claim, a combination of sociological evidence of discrimination, numbers evidence of discrimination, and evidence that suggests invidious discrimination, in other words, statements by lawmakers or statements by discriminatory actors, say employers, are used to determine whether there is a discriminatory hiring practice or discriminatory governmental practice. So looking at what you might characterize as types of sociological evidence is something courts not only are accustomed to, but they actually do frequently. So the mere fact that one of the, and of course, all courts in every context deal with findings of fact. They deal with factual presentations. Most legal cases in almost every context deals with factual material that has to be decided. I think the reluctance of the Supreme Court in this arena is that they're afraid that no matter what they decide, they're going to be accused of putting their thumb on a partisan scale, one side or the other. And so since all data requires interpretation, they're afraid of the interpretation piece of this. But I think the flaw in that reasoning, from the standpoint of Justice Roberts' reasoning, is that making a decision that these are non-justiciable claims is making a very profoundly partisan decision. And so I just don't think the partisan features of these cases are escapable. And I don't think the Supreme Court should be trying to escape them for that reason. And it just seems like this is kind of a pretext for escaping what is a problem that the court has no choice but to address.
I think that, did you say something? So, to piggyback on the judge's point, if the court does decide that these particular claims are non-justiciable, essentially what litigants will do then is just dress them up as race claims. That's what will happen. They'll try to find some other doctrinal box to put this in. And so, really it's unavoidable. And I really like the point about the decision to not take these claims being a partisan one, because there is a partisan bent to all of this. And honestly though, I wonder about whether or not the court is concerned about taking a hit one time, right? Saying, look, we're not going to deal with these types of claims, they take a hit, versus taking a hit every time they hear one of these cases, right? And so Chief Justice Roberts might figure that on balance it's better to just take the hit one time and move past it, as opposed to continuing to embroil the court in these disputes. But I would posit that they can't avoid it. It just will masquerade as something else, as these claims often do.
Well, let's spend a little time discussing the court's actual ruling in this case, which has to do with standing to bring a partisan gerrymandering claim. Does the court's new standing rule make any sense? Is it partisan gerrymandering a feature of statewide electoral maps rather than individual districts? And if so, why should plaintiffs be forced to challenge it district by district? I'm going to throw this one to Professor Massaro first.
Well, I don't think it's entirely new. There's an older case in which they say you have to belong to the district in order to challenge the imperfections of the district. And it's always struck me as odd, because if you think of the state of Wisconsin like a rubber doll with sand in it, right? And you've got a district. You push down on one district, it's going to squirt out into the next district, and there's a boundary. It's the contours of the state of Wisconsin. But it's hard to see why those consequences aren't obvious to the court, one. Two, I think of something, a comment that a representative, this blew my mind, someone from who sits in our state legislature said recently, you know how it really works, and this goes to the point of what happens here affects the whole state. Say the Democrats get X percentage of the vote statewide, and the R's get a larger percentage of the votes. And she is a Democrat and was told, but this legislative session, you don't get a proportional number of bills that you get to get through. You get one. Let it sink in for a minute. I mean, there's nothing about it. It's like a winner take all. And we have the votes, and we'll give you one that we want to sign off on. And I think the average Arizonan would go, you've got to be kidding me. There's something about the one person, one vote, and something like proportionality and representing all of us that is masked if you just look district by district and what happens in that district, as though it doesn't collectively have a consequence in terms of what the legislature can or cannot do. But I think they've looked at it that way. You got to live there and show the harm there in order to have standing there for a long time. And that's why I think the pivot to the First Amendment argument it might end up being so important.
Judge Eckerstrom?
Well, the four justices who were in the minority on this particular point, they agree with they're not a minority on the principle that you have to show a harm in your particular district as an isolated, particularized argument. But the four dissenting justices take the view that there should be another way you can show harm in addition to that, that involves more sophisticated notions of freedom of association. If you're a Democrat, you're getting harmed statewide because your influence is being watered down. But they agree with the majority on outcome and are only concurring because they don't believe that point was factually argued or factually supported by the plaintiffs below. But they're writing specifically to encourage those particular arguments about standing to be made and fleshed out, and they're hoping that those become part of the future jurisprudence. The points in the writing that Professor Massaro was just making about the impacts that you suffer as a voter, even if you're in a district where your political party is the majority. And also, if you think about it, there are two ways that gerrymandering is done, and the majority decision even candidly talks about them. It's packing and cracking, right? And why should someone who is in a district that has been packed, who is of the majority of the packing, not have a claim, as opposed to someone who's a district that has been cracked? And that's a subjective thing. It just depends on what party you are and in what particular district. And it doesn't make any logical sense in terms of the mechanics and the motivations for executing what you might characterize as a public harm in the cases.
Professor Tolson, could you briefly explain the concepts of cracking and packing for members of the audience who may not be familiar with those terms? They've been used a couple of times here, and they're obviously centrally important in this area.
Here in Arizona, we think packing means something else.
So packing refers to a gerrymandering technique where you put an excessive amount of voters of one party in a single district well above what's needed for the representative to win that district in order to concentrate his votes. Cracking is when you split up voters of a party so that they cannot form a collective around a particular representative because they're split among districts. And so those are the two most common ways that parties engage in partisan gerrymandering. To go to the question about the standing, I think it's really interesting, Justice Kagan's opinion, because she lays out a roadmap for litigants to litigate these claims going forward. And the First Amendment harm is something that she didn't feel was developed, but I do think it remains a very promising route for litigants to take, even with Justice Kennedy not being on the court anymore, because she's basically signaling that she would also welcome those types of claims. To me, it raises an interesting question about whether or not voters have an interest in their party doing well, right? That's an interest that's sort of beyond a voter's interest in voting for a representative of their choice, right? You can say that that's intricately tied to the vote dilution claim. My vote is diluted. I cannot elect or vote for a candidate of my choice and have an effective vote, right? That's the nature of the vote dilution harm. She's talking about something different, right? She seems to suggest that the First Amendment harm is one of voters' inability to relate to like-minded voters such that the party is doing well. Right, and that's a harm that reverberates statewide. And I thought that was a really interesting way of sort of thinking about the issue there, because I don't know if I thought about Justice Kennedy's First Amendment stance that he took in Veith in that way. Right, he talked about a potential First Amendment claim there, but it seems like she's going into more detail about the harm that could potentially result on First Amendment grounds. But it also raises the question of whether or not there's enough justices there to agree with that, because I don't think that they agree about the harm that can result from partisan gerrymandering. It's very clear that the majority there in finding that Bill Whitford doesn't have standing is thinking about it in terms of vote dilution. She's not really focusing on that. She's focusing on First Amendment. The First Amendment claim is one where evidence where statewide evidence is relevant, even if it's not relevant to a vote dilution claim. And so I wouldn't be surprised, and I think they filed an amended complaint at this point for the plaintiffs to sort of take the First Amendment road.
So just to be clear, the opinion of Justice Kagan that both Professor Tolson and Judge Eckerstrom have referenced here is a concurring opinion. I describe this opinion, this case as a unanimous decision, and all 9 justices did vote to dismiss this case for want of standing, but Justice Kagan and 3 other justices concurred in what could be interpreted as a kind of quasi-dissent, laying out 2 distinct alternative standing theories which might allow, and I think she suggested would allow, most or all of the plaintiffs in the Wisconsin litigation to proceed with their claims. And unlike a typical dismissal for want of standing, this case was actually remanded back to the 3-judge panel, so these plaintiffs will have another opportunity. I have one last question for Professor Tolson before we open things up to the audience here. I hope that I'm not imposing too much on your special expertise here, but we're all eager to hear from you about these questions. And that is why the plaintiffs didn't develop these alternative theories of standing if, in fact, they were so ready to be found, or as ready to be found, and had as much support in the case law as Justice Kagan's concurrence suggests.
I think they were really excited about the efficiency gap. I think that they, and I'm speculating, felt that they had found a standard that a majority of the justices could get behind. Because although it is social science, if you read Nick's article, it seems fairly straightforward, like just straightforward math. So I think because of sort of the ease of understanding what the test encompasses, I thought that, you know, they figured the justices might sign on. Other than that, I don't know why they did. And I know they're probably kicking themselves.
Do you think that the court's description of the plaintiff's standing, the plaintiff's position on standing, and the evidence supporting that position is a faithful rendering of the briefs and of the record? My sense after reading the court's opinion was that the majority opinion adopted an extremely ungenerous reading of the plaintiff's papers on the standing question, that a more sympathetic court, a court that was not so eager to punt this case, could easily have discovered in the briefs and in the evidentiary record evidence of a client that would have established standing even under the majority's understanding of that doctrine.
Yes, certainly. I do think it was an out for them, but I want to say, to be fair, although I don't know, I might be giving them more credit than they deserve. I don't think that they were ready. I don't think they knew what to do. I think that they needed more time to try to figure out what the appropriate standard would be. I don't think all of them were sold on the efficiency gap. The efficiency gap, by the way, is not the only standard out there. There are other things floating around that the court certainly could have relied on. I know Joey Chan out of University of Michigan had also proposed a standard where he runs different simulations under various maps, and if the map falls outside of, and it's like 500 simulations, if the map falls outside of the 500 maps, then it's gerrymandered, right? So it wasn't as if the efficiency gap was the only proposed standard. I believe he filed a brief in the case as well. So there were things floating out there that the court could have relied on. I just don't think that they were ready to make a decision. And as you can see here, they agreed to kick it on standing, but you have basically two opinions here where they're talking about different things. The majority is talking about vote dilution, and then the concurrence is talking about First Amendment. They have to come to some sort of agreement on the basic constitutional questions before they can pick a standard.
So we'll take questions for the remaining 8 minutes or so here, right here behind you, Francie.
Yes, how does the fact that the independents are growing in number, and how does that factor into the partisan part?
I have a little bit of an answer to that. In terms of the, at least voting assessment, they usually when these maps are being worked with, they don't necessarily go in terms of figuring out partisan predictions in terms of outcomes. They don't exclusively look at voter registration, say, in a particular district or not. They look at actual past partisan performance of a district. And so their computer models can tell them in this real estate, as to if we collect these precincts together, what is their partisan affiliation outcome been in the past? Is it an R+7? Is it D+15? And then they can change the precincts, and their computers will spit out what the past partisan performance is too. So I think independent voters become part of that data pool. So an independent voter that usually votes Democrat is going to be identified that way. When that usually votes Republican will be identified that way. One that votes sometimes Democrat and sometimes Republican will come out on the statistical wash, I think is the theory when they assess that.
In the front here.
Thank you all for an excellent presentation, first of all. Multi-part, I'm going to try to keep it brief for Professor Tolson, or anybody. Pennsylvania has said, we've had it, we're not waiting for this anymore, we're going to do it on state law grounds. Basically. So, outlier or bellwether is Pennsylvania. What standard did they use? Can they decide congressional gerrymandering, U.S. congressional? And will the fact that states decide this potentially force the Supreme Court to deal with it, to have a national standard for gerrymandering on equal protection grounds or some other grounds?
Thank you. Very meaty question.
That's a great question. So as of right now, I think it's an outlier, in part because the cases just aren't being litigated like that on state law grounds. Now keep in mind, they could be, right? This is definitely an area that hasn't been mined. And Pennsylvania in particular, and I think most states have provisions in their state constitution that allows for free and fair elections, and that was the grounds for the Pennsylvania decision. And so because most states have those provisions, arguably you could see state litigation going through state courts that attack partisan gerrymandering on state law grounds. The Pennsylvania case wasn't the first case to do that, but there hasn't been a ton. And you would think that people will pursue that given the deadlock in the federal courts. With respect to congressional districts, I think that you can use state constitution to attack congressional districts because the time, place, and manner clause gives states the ability to draw the districts for congressional districts in the first instance. And so they can provide for that in their state constitutions, they can attack it on state constitutional grounds, but then of course that presents a federal question that will go to the Supreme Court. And so then we have the same problem. Although, I hate to call it the judge, but you may have some insight on this. But would that be a situation where you have the U.S. Supreme Court reviewing a state court judgment about the state constitution, which might be problematic?
Yeah, well, to the extent it would be, the claim would be presented under a state constitution, then the Supreme Court, the U.S. Supreme Court, would have no jurisdiction over the case.
Even though it's congressional.
And the state Supreme Court would be the final arbiter. But to the extent your, well, if it was being applied to U.S. congressional districts,
right,
then I would think the U.S. Supreme Court would definitely have jurisdiction. But it'd be surprising for the claim not to be raised on both grounds if you had, the plaintiffs in that case would officially raise it under both the United States Constitution and the state constitution. And I would, so I think the Supreme Court would have jurisdiction over that type of a case under any circumstances.
Well, what if the plaintiffs only litigated on state law grounds? I like that.
Is it still Article 1, Section 2 or whatever that says this is how you're going to apportion the Congress?
And so it's the elections clause, which is what, Article 2, Section 3 or something like that. I'm sure I'm wrong about that. But even though the elections clause gives the states the authority, it's a delegation to the states, it isn't the source of the claim, right? They're attacking the districts on state law grounds. And if they just stick to state law, it seems like that would deprive the U.S. Supreme Court of jurisdiction, even if it's congressional districts. I feel good about that.
Any other panelists care to chime in here?
Come on, Toni, say it.
I think she's right. And I think of a parallel, though it's not on all fours, where we got going with litigation insisting on equal funding of schools. And the court walks away from it and says, oh, we can't handle this. And then state litigation ensues on the basis of state constitutional law. And if they stick to their state constitutional law arguments, then I don't think the Supreme Court would have jurisdiction. Andy?
That sounds right to me.
In the absence of a supremacy clause claim by someone at a later time.
Or equal protection, or whatever else. Yeah.
Right.
It's a great question.
Okay. In the front.
I have a few observations. First of all, Pennsylvania, Pat McCrory had been governor, and
1 sec, sorry. Move it just a little away from his mouth.
Could you move the microphone a little further from your mouth, please?
Thank you.
Thank you very much.
McCrory had been governor, and to uphold certain personal or traditional sexual values. And then Adam Silver, the head of the NBA, commissioner of the National Basketball Association. No, wait, we'll take our, you can't do that. And one of the most glaring things is about what happened with Justice Kennedy. He moved against, he gave gay persons certain rights, or transgender persons certain rights, and despite that, now that might be taken up by the current Supreme Court, Senator McCain has gone on record, and he was buried in he took Senator McCain wanted traditional marriage to come back to the United States. He expressed this when he's buried, but in his
I'm sorry, we're almost out of time. Is there a question?
Okay. And we hope that that the new Supreme Court Justice, what's his name? Kavanaugh will find an Irish name, will possibly rule against bring back traditional marriage.
I'll take it.
And thank you.
We're going to, if you have the time, in the last section, we'll talk about the implications of a potential Kavanaugh in the absence of Kennedy across a band of issues. So we'll address, I hope we'll get to that later.
Very good. Thank you so much. We will resume at 2:50. Okay, we're going to begin our third panel, so if you could take your seats, that would be wonderful. Thank you. The First Amendment of the Constitution prohibits Congress from making any law respecting an establishment of religion. This Establishment Clause has long been understood to prohibit not just the formal establishment of a church, but also discrimination in favor of one religion over another. But what exactly qualifies as discrimination for constitutional purposes? This can be a tricky question in practice, but the rule for identifying unconstitutional discrimination is at least superficially straightforward. Only intentional discrimination counts. Government actions that merely impose a disproportionate burden on some religious group do not count as discrimination on the basis of religion unless they are motivated by a discriminatory purpose. This rule is more easily stated than applied. What does it mean for the government to be motivated by a discriminatory purpose? Is it enough that the government knew its actions would disproportionately harm some group and moved ahead anyway? Or must the government choose to act because of, and not despite the discriminatory impacts of its actions? In other words, is government discrimination limited to actions that are motivated by a bare desire to harm some group, or is willful indifference sufficient? Does it really make sense to speak of multi-member institutions like legislatures or administrative agencies as having purposes or intentions at all? If so, how are those intentions or purposes to be identified and proven? Can we call agency employees or legislators as witnesses before the court? Can we really expect them to tell the truth if they are willing to appear? What if some legislators or agency employees acted from a discriminatory motive and others did not? To avoid grappling with these types of difficulties, courts have generally made discriminatory purpose very hard to prove. Every once in a while, however, a case comes along in which the evidence of purposeful discrimination is so blatant that it is almost impossible for a court to ignore. The next case that we will be discussing is one such case. At least that is how several lower federal courts seem to have seen it. I'm referring, of course, to the travel ban case, whose official name is Trump versus Hawaii. A little background is in order. On January 27, 2017, President Trump signed Executive Order 13769, titled Protecting the Nation from Foreign Terrorist Entry into the United States. For ease of reference, I will call this the first order. In substance, this order temporarily banned all travel to the United States by citizens of 7 Muslim-majority countries and suspended admission of refugees from certain countries indefinitely. Implementation of the order was immediate and chaotic, with valid visa holders and green card holders stranded at U.S. airports and turned away overseas. Numerous lawsuits followed in short order. On February 3, 2017, a federal district judge in Washington temporarily blocked most of the order's provisions from going into effect on the ground that it was motivated by anti-Muslim animus. This decision was upheld on appeal, affirmed on appeal, And eventually the Trump administration withdrew the first order and replaced it with a substantially similar but more carefully drafted order numbered 13780, which I will call the second order. The second order, too, was temporarily blocked by the lower federal courts as unconstitutionally discriminatory. The Supreme Court upheld these decisions in part and reversed them in part. These are preliminary injunctions, without deciding on the merits of the plaintiff's constitutional claims. By its own terms, the second order expired in early October of 2017, and their administration replaced it with an even more carefully drawn, but still substantially similar Proclamation 9645, which we can call the third order. This order, too, was initially blocked by the lower courts in most important respects, but the Supreme Court intervened to allow the order to go immediately into effect pending further appeals. When the court heard oral arguments in the case, the plaintiff's principal contention was that the third order, like the first two, intentionally and thus unconstitutionally discriminated against Muslims based on their religion. Because the order did not explicitly or facially discriminate against Muslims, it barred all citizens of the 6 affected countries without regard to their religion. The plaintiff needed to establish that the order was motivated by a discriminatory purpose. At the heart of their case was a series of statements by President Trump and his advisors. I'm just going to give you a short list. It is by no means exhaustive. While a candidate on the campaign trail, Trump published a, quote, statement on preventing Muslim immigration that called for a, quote, total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on, end quote. That statement remained on his campaign website until May of 2017. Then candidate Trump also stated that, quote, Islam hates us, and asserted that the United States was, quote, having problems with Muslims coming into this country. On December 8, 2015, Trump justified his proposal during a television interview by noting that President Franklin D. Roosevelt, quote, did the same thing with respect to the internment of Japanese Americans during World War II. In January 2016, during a Republican primary debate, Trump was asked whether he wanted to rethink his position on, quote, banning Muslims from entering the country. He answered, no. A month later, in a tone of evident approval, Trump told an apocryphal story about United States General John J. Pershing killing a large group of Muslim insurgents in the Philippines with bullets dipped in pig's blood in the early 1900s. The plaintiffs further pointed to a series of statements by the president and his advisors indicating that the third order was just a, quote, watered down or dressed up version of the Muslim ban that Trump had promised on the campaign trail. The president countered with 4 constitutional defenses. First, he argued that the order was within his statutory authority to suspend the entry of any class of aliens whenever he finds that their entry would, quote, be detrimental to the interests of the United States. Second, that the order was necessary to prevent the entry of these foreign nationals about whom the United States lacks sufficient information, and to elicit improved information sharing practices from foreign governments. Third, that the president's immigration decisions, because they implicate foreign policy, should and historically have received extraordinary deference from the courts. Fourth, that this deference made it inappropriate for the U.S. Supreme Court or any other federal court to look beyond the 4 corners of the order itself for evidence of a discriminatory purpose. A 5-justice majority of the Supreme Court largely agreed with the president. Justices Kagan and Breyer issued a cautious, narrow, and lawyerly dissent, emphasizing the administration's failure to issue case-by-case waivers in appropriate circumstances. Justices Sotomayor and Ginsburg issued a far more impassioned dissent, which Justice Sotomayor read from the bench, comparing the majority's decision to the Supreme Court's notorious decision upholding the internment of Japanese Americans during World War II. Some questions for the panel. First, Section 1182F, which is the statutory basis for the President's order, Section 1182F of the Immigration Nationality Act, seems to give the President very broad authority to suspend the entry of any class of aliens that he deems necessary. On the other hand, Section 1152 of the Act provides, and here I quote, No person shall receive preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence. Purely as a matter of statutory interpretation, and we'll give this first to Judge Eckerstrom, who does statutory interpretation all the time, can President Trump's travel ban be squared with this anti-discrimination principle?
So the way a statutory claim would be evaluated, I think, from a constitutional standpoint, as well as a state statutory standpoint, is that the legislation all the time and statutes all the time make a variety of distinctions that can have disparate impacts on people. And so the standard of review that would be employed would traditionally be deferential in the absence of any specific evidence of an invidious intent to discriminate in the context of discriminatory statutes. And I'm not sure that I think this would be classic evaluation of 14th Amendment law as well, in application as well, in terms of applying statutes that energize or protect the 14th Amendment. And so the question is, what would our standard of review be? And traditionally, if we were to apply in the absence of any evidence of intent to discriminate, or evidence that it impacts a suspect class or is intended to target a suspect class, we would do a rational basis analysis. And in this area, the choice of the standard of review is often the choice of what the decision or the outcome of the case is going to be, right? Because if strict scrutiny is applied, where you have to have narrowly tailored provisions directed at a compelling state interest, that's usually the court clearing its throat to strike down a piece of legislation on the grounds that it isn't narrowly tailored enough, and that we can conjure a way it could be tailored more narrowly so it wouldn't have the impact that's being complained about, right? By the same token, when a court says we're going to apply the rational basis test, they're clearing their throat usually to affirm, because the rational basis test is very, very kind to the enacting body, whether it be the chief executive or whether it be the legislative body. And so, for example, here, the majority opinion essentially says that really, so long as there is a motivation here that is non-discriminatory, then this would pass a rational basis test. And so, to me, what's interesting about this case is the test that's chosen. And that brings us back a little bit to I think what's interesting about this is a comparison to the Korematsu case, which President Trump expressly relied upon. Because what's interesting about this case is that the majority opinion, for the first time, has the United States Supreme Court expressly stating that the Korematsu case is not good law anymore. Korematsu versus the United States, it says, is abrogated. And it also expresses in another sentence, and I don't remember exactly the words it used, but a specific distaste for that case. And it is something our Supreme Court never does anything like again. What's interesting, however, is that in Korematsu, the Supreme Court applied a strict scrutiny test. The very first sentence, the very first paragraph of the majority opinion in Korematsu, which is upholding the internment of Japanese American citizens, is that we have we apply the highest level of scrutiny to actions like this that affect based on racial characteristics, a segment of our population. And so Korematsu can be interpreted as the only case in United States Supreme Court history where they've applied strict scrutiny and still come out with the result, at least in that context, that it passes muster. And that was in part because they viewed the fact that we were at war with Japan and there was a threat of invasion on the Pacific Coast as a compelling state interest, the national security interest, and so forth. But what's interesting is that in abrogating Korematsu, they then apply a much, much more relaxed test for future cases that might be similar to that, right? So they say Korematsu's off the books, but in Trump versus Hawaii, we're going to apply a rational basis test. And the dissenting opinion by Justice Sotomayor chides the majority for that, recognizes that as a particular problem with the case. But of course, as soon as the majority has chosen the rational basis test, it's clearing its throat to approve the piece of the executive's authority.
There's a huge amount of interest in everything that Judge Eckerstrom just said. But I would like, just for a moment, to direct the attention of the other two panelists back to the statutory text that I originally asked about, which is Section 1152 of the Immigration and Nationality Act, which provides that no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence. President Trump's third order, of course, explicitly on its face treats immigrants from the affected countries, that is, immigrants of the affected nationalities, differently and worse than other groups of entrants or would-be entrants to the United States. And so I was curious whether the other two panelists, I think Judge Eckerstrom's already opined on this question, but I would be interested in hearing from Professor Massaro and Professor Tolson about whether you believe that the order can be squared with this statutory language before we get to any of the very interesting constitutional issues that Judge Eckerstrom also raised.
I actually think that the majority's statutory interpretation analysis is not that tortured. I think the distinction that the majority is trying to draw here is between individuals who are admissible versus the world of individuals who are trying to get immigrant visas, right? So if you just focus on individuals trying to get immigrant visas, that's when you have the non-discrimination requirement versus the president's authority to decide who's admissible, which applies to both immigrants and non-immigrants. That's a much broader category of individuals. And so the court's point is that with respect to the issuance of visas, there's a non-discrimination requirement, but with respect to the president's authority to determine whether or not someone's admissible, then that requirement doesn't apply. Now, of course, that's separate from any constitutional issues that are raised that the president has discriminatory intent. But in terms of statutory analysis, I thought that was a pretty fair reading of the statute.
Professor Massaro?
Correct. I mean, I think that that's what the court did, you know, and distinguishing between entry and the issuance of the visas, and so superficially, good reading of the statute. But a counter argument, which I think is powerful, is that's a really wooden reading of the statute, because what do you get a visa for? Just to sit at home and say, I got a visa. The visa is to do something, and there's a vetting process. It's not easy to get a visa, and so, you know, reading these things together in a way that might make sense as a matter of statutory interpretation it undermines, I think, the wooden way in which they read the distinction between entry and issuance of a visa. And I think the argument was made by the lawyers and also has been made since on behalf of what happened here. So I think that yes and no would be my answer to that. I was surprised, since the Ninth Circuit opinion that they took, cert on, this was the gravamen of it, was the Ninth Circuit panel saying, you know, this was a question of statutory interpretation, and the non-discrimination statute trumped the more general authority that the president possesses. I thought they gave really short shrift to the analysis of the Ninth Circuit, and I'm not sure why. I was on a panel with Judge Hurwitz on Friday and really felt that you know, that it was unfairly dismissed and not really engaging with the thrust in terms of the Ninth Circuit argument, and I concur. But think about it. If you would set one, well, I'll stop there because you've got other questions.
Add something.
So I agree with that, even though I sort of feel duly chastised. But
that was not my intent.
Sorry. It is weird. I agree. It is. Does it pass the smell test? Sort of. You know, I guess it's definitely a plausible argument. But she's right. Like, what do you get a visa for?
The court was with it, not you.
I definitely think, though, it has a lot to do with the court's view of the executive, like what the executive is supposed to do. I think the majority is endorsing a view of executive power where it's, I don't want to say unlimited, but we're definitely getting to that, right? So I think the majority was very uncomfortable with any reading of the statute that would constrain executive power, right? They thought that the president had authority, one might even say beyond the statute, to determine admissibility. And so I think engaging in this wooden interpretation of the underlying statute furthered that particular goal of strengthening the presidency.
Reading Trump versus Hawaii alongside Masterpiece Cakeshop, a cynical reader might conclude that the majorities in these cases care more about religious discrimination against Christians than religious discrimination against Muslims. Or perhaps that they care more about religious discrimination by Democrats than religious discrimination by Republicans. Would that conclusion be unfair? Can the outcomes of these cases be reconciled in any principled way? And we'll start with Professor Massaro.
I don't think it's entirely unfair. I think it's impossible for me to imagine a comparable executive order aimed at predominantly Christian nations in the immigration context. Now, there may be lots of reasons you would want to generate for why that's the case, and again, to the direct promises to that effect of President Trump in the original order that minority religions in the affected countries would be, members of those would be protected. And it was not disguised that it was a hat tip to, among others, Christians in those countries who would be protected. So, you know, and using the statement of the commissioner in the Colorado case, who says, I think it's despicable to use religion in this way to subordinate the rights of others as a defense, and go, boom, gotcha, and not take the single author of the executive order to task for statements made both as a candidate and subsequent to it, does sort of ring out with potential unfairness, which tracks back to Professor Tolson's point, is that when it comes to presidential powers, all bets are off. And you know, they're applying a rational basis test, not the normal test that's applied to Establishment Clause questions. It reeks of almost unitary executive theory and apprehension about invading the space of the president per se. But no, I don't think it's completely unfair, and that's why Sotomayor pointed it out.
Judge Eckerstrom, you focused earlier on the traditional deference that courts show to the executive branch, administrative agencies, in this case the president, in both applying statutory law and evaluating whether the executive is acting within statutory authority as well as in the constitutional context. Does that seem like a plausible basis to you for distinguishing this case from Masterpiece Cakeshop?
Well, I mean, the Supreme Court distinguishes it arguably in two separate ways, and they do it more in the context of distinguishing why this isn't Korematsu. But they say, first, national security, the president, in the context specifically of national security, gets the utmost deference. And then their second argument is, we're not talking about American citizens here. They point out that, they say it in part to explain that executive authority is also extraordinary in the context of immigration, but they also point out that we're not talking about a direct infringement on the rights of United States citizens like we were in the context of Korematsu. So those could arguably be distinctions about why you would also treat the Colorado body differently than the chief executive. But in that vein, I think it's really a really interesting question in terms of, if you look at the history of presidential assertions of national security that impinge upon the rights of American citizens. And make no mistake, there's an argument that this actually, to the extent it violates the Establishment Clause, impinges on the rights of Muslim Americans, to the extent it sends a national signal that there are preferred religions and unpreferred religions that goes beyond immigration law. But there is I would submit that there is a history with regard to authority in times of war and in times of national security threat that would suggest that our Supreme Court should actually be more vigilant rather than deferential in protecting our citizens' civil rights. So, and I think you could say, so during World War I, we had the Abrams case, United States versus Abrams. It's a famous case in jurisprudence of the First Amendment because it's the case where Oliver Wendell Holmes, in dissent, sticks up for the right in 1917 of Russian immigrant Bolshevik sympathizers to exercise their First Amendment rights to to distribute pamphlets challenging the propriety of the war against Germany. They're infuriated because the United States government has decided to no longer ally itself with Russia when Russia had its revolution and became Bolshevik. And so they send out pamphlets, and what's extraordinary about that is that was in violation of a wartime act of the legislature that impinged upon their First Amendment rights, and they were, it was big stakes. They were 4 people who were 20 years in prison was the consequence, was the sentence for generating these pamphlets criticizing the American war effort in 1917. And the U.S. Supreme Court was challenged to decide whether those people would serve 20 years in prison or whether they had a First Amendment right to take the acts they did. The majority found that 20 years in prison it was. Justice Holmes writes furiously in dissent. But that is a context where I think in hindsight that's a case that our country is not very proud of and has been overtaken and disfavored in the law. But again, perception of a national security interest, this time by the legislative branches, was Congress. And the Supreme Court saying we have to be deferential to that, and First Amendment rights aren't as important as that. And then you have Korematsu, next World War, World War II. We have Korematsu, right? Again, extreme deference for national security interests in time of war, so as to justify the actual placing of our part of our citizenry in concentration camps, right? Although we apply strict scrutiny, the ultimate outcome is that we're so deferential that strict scrutiny, even under strict scrutiny, we don't, the Supreme Court doesn't defend that constitutional right of citizenry. So the history of this country is that in times of national security threat, that is a time when we better be the most careful about our civil liberties. That is the time when we need the Supreme Court most to protect our civil liberties. And remember, we talked about the role of the Supreme Court to protect minority interests against majority passions and inappropriate majority takings of individual civil rights. I do think it's times of national security threat where minorities who oppose the position of the majority most come under the impassioned ire of the majority and are most targeted for what are fairly extreme outcomes. And so I think there's a historical argument that the Supreme Court's just got it flat wrong in terms of whether it should be especially deferential in the context of national security interests. Now, that's neither here nor there in terms of where the jurisprudence is. We had the Hamby case, which intervened to talk about Guantanamo and whether a U.S. citizen had a right to any due process under habeas corpus to evaluate whether he was truly an enemy combatant. And the Supreme Court 9-0 decided he was entitled to more due process than he got, and that he was interestingly entitled to more, that the courts did not need to simply accept the Moss memorandum, right? They did not need to accept at face value the government's assertions about why they thought he was an enemy combatant, but were entitled actually to do factual development and factual challenging to some degree of those particular conclusions. So here we have what seems to be a face value government acceptance, again, of a memorandum, in this case, without any critical analysis of it by the majority. So it was kind of long-winded, but I think in the history of this area, I think there's reason to question whether this sort of accepted notion that we defer to the chief executive in times of national security is the appropriate thing for our Supreme Court to be doing.
Let me just ask a quick follow-up. Do you think there's a difference between a court deferring to the executive's balancing of the evil of racial discrimination against national security interests and simply deferring to the executive by refusing to examine the underlying motivation of a challenged action like the one in the travel ban case? Because the two forms of deference here seem to me like they're doing different work. In Korematsu, whatever one thinks of that decision, the court recognizes that this is an especially problematic assertion of executive authority because of its racial basis and weighs that constitutional evil against the executive's supposedly greater competence in protecting the nation against national security threats. In the Trump versus Hawaii case, the court does something subtly different, which is to say, we're going to defer the executive by not looking behind the four corners of this order to see whether there's an evil to be weighed against the executive's supposedly greater competence in this context. Do those two strike you as meaningfully different, and do you think one situation justifies greater deference than the other? And I'll just put right back to Judge Eckerstrom.
I think when in the defense of the constitutional rights of our citizens, when it's the last recourse, I'm not impressed with deference when you have a discriminatory impact and when you have so much evidence of an intent to violate the Constitution. I don't know why you would have deference when the lone spokesperson for the branch you're talking about, which is the President of the United States for the executive branch, has given such overwhelming evidence of what the true intentions of the law would be. So I don't think the answer that it's in the arena of national security or that it's we're dealing with immigrants as opposed to United States citizens were satisfying answers to why that level of deference was provided.
Professor Tolson, would you care to add anything?
Not really. Maybe I'll add by explaining my not really. I think the distinction is an interesting one, but I don't think it matters, right? To the extent that the court is supposed to be an institution that protects minority rights, to sort of piggyback on the judge's point, Hawaii versus Trump, they pretty much abdicated that responsibility. And honestly, I find the use of rational basis review here to be somewhat offensive. And I understand, the competing interests. And, I've been thinking in my research about what do you do when constitutional structure and constitutional rights conflict. But it seems to me that deference doesn't mean that the court has to be blind, right? The court could, like, in a serious manner, evaluate the order. They could, in a serious manner, evaluate the comments that the president made in the context of the order, and then come to a determination about whether or not the national security interests are warranted. Right, because the dissenting opinions make a very important point about the fact that the order is not being implemented and used in a way that it says on its face, right? Like they are not granting exceptions when they're supposed to. And so when you think about the discriminatory application and you think about the president's comments, then you do have to wonder about the supposed national security interests and whether or not the proclamation was needed. And so, to me, the court's job is to evaluate those things seriously and not just simply defer to the executive branches because they claim national security. In that way, it does look like Korematsu. To me, the difference is that in Korematsu, the court paraded behind strict scrutiny and it didn't have any teeth, which is just the irony of the case, because it's, I think, the first time the court articulates strict scrutiny for race-based discrimination. But here they don't even pretend, right? There's just, okay, rational basis review. And I'm with Toni in the sense of saying that if this was against Christians instead of Muslims, this case would have come out totally different. And I am just completely bothered by that. So, not really.
So, it's already been mentioned several times that in upholding the travel ban, Chief Justice Roberts went out of his way to repudiate Korematsu versus the United States, the infamous decision that upheld the internment of Japanese Americans during World War II. Why do you suppose he did that? And does he deserve credit for doing so? Professor Massaro?
Well, President Trump invoked FDR as support for what he did. And Sotomayor shamed the justice into responding to this because the lion's share of her dissent was devoted to the Korematsu question. I think, too, that the court, in answer to your the last question, I think the court pivots in their opinion away from looking at Trump and looking at the office of the presidency and protecting the office of the presidency. But when you peel it back, the analogy to Korematsu is on several fronts. It isn't just the bias, it's also the lack of particularized evidence. So there's a due process question as well as an equal protection question as well as a religious discrimination question, all of which should enable us to overcome even substantial deference. Only by trafficking the very worst form of essentialism and rank hostility to people based on the actions of some of them, that was Korematsu. Is this isolation of predominantly Muslim countries defensible? It rests heavily on a Muslim equals enemy conflation, just as Korematsu rested on a Japanese equals enemy conflation. But that's not all that was wrong with this. The Breyer opinion dealt with the fact that on its face it says, we'll provide waivers, don't worry. We will look into each person who can generate the argument that I'm not the enemy. And he says, well, how is it that 8,400 people applied for the waivers and only 2 got them, right? So it's not just the statements that he made. You have to travel a lot of territory to get to the point of invading presidential discretion here, which they don't do even after. It's due process, equal protection, rank animus, conflating Muslim with the enemy, and then at the end of it saying head fake, separation of powers, head fake, president, we're not going to peel it back, etc. Okay, that's the bad news. And then they say, but the good news is, this case isn't particularly good news for President Trump or for future presidents. It's bad in a lot of ways, depending on your perspective. But it isn't that they didn't tell the American people and everybody who reads the U.S. reports forever what the president said. So they did, they may say you cleaned it up by version 3. They may say you did this right and national security, et cetera, but the cumulative effect is a pretty close look at what he did and a chronicle of it, and then the Kennedy lament at the end. So if you can spank a president, I think this happened here. But how much worse for the people whom this order affected? 150 million people affected by this order. I don't know if that's your answer to your question, Andy, but it is what I wanted to say.
Well, let me shift gears and ask you all, what is the most plausible argument for the court's decision? And what, if anything, is wrong with that argument? And we'll start here on the other end with Professor Tolson.
I do think, to go back to a point that was made earlier, this is about the unitary executive. I think that the court has a certain view of the president as all executive power, sort of flowing from the president, and they didn't want to constrain him. And so I think everything flows from that premise, because it's the only way to understand why the court was willing to subordinate the religious rights of the individuals here and not subordinating the same way in a Masterpiece Cakeshop. It's the only way to understand the very formalistic statutory interpretation that the court engaged in here. And I think at a very basic level, this is about ensuring a strong executive.
Judge Eckerstrom.
This is a hard question because I'm not a big fan of this case. So I think what can be said positively about it is that there is at least an undertone of judicial modesty in terms of how it handles the branches that are entitled to do fact-finding. And so that would be a positive feature of it. Obviously, the judicial branch is not the branch that's entitled as to national security questions and to immigration questions to be the primary judge of what facts are the most important ones and what political judgments are the most important ones. So there is in it deference to the political branches who are entitled to set the policy the political branches are entitled to set. President Trump, whether anyone is a fan of his or not a fan of his, was elected president. He was elected president in part because of the things that came out of his mouth about immigration, right? And at some point, the Supreme Court has to show deference to that as well. So I guess that would be what I view as the positive features of it.
Professor Massaro.
I think it was a very predictable case, and even though it was close. I think there are about 7 reasons. One, the president's lawyers did clean up the language. They did. If 3 had started it and not 1, I think it would have been a much easier case for the president. Second, separation of powers. Boom. 3 is they're saying protection of the presidency, while creating some room to remark on this president and issue a warning. We're not giving up all discretion, and we do think this is justiciable. And I think that's important. Additionally, fear of making bad law. You have to think how the opinion's going to write. and where the court quickly veers into incompetence or undue incursion into executive power. Another one, though I hope not, is maybe a creeping underlying belief in the unitary executive theory, which is a very encompassing president gets to do it theory that we need more time to develop. And then the last two, I think one would be perhaps a naive confidence that this will sort itself out through elections. You know, you may say that's separation of powers, but I think at some level there's a bit of a, there must be a pony beneath this, or it's up to you. We can't solve your problems. At some point you just have to vote in a way that prevents these kinds of outcomes. And then last, it must be said, selective insensitivity to religious discrimination. I think that's part of it. Just last term, the court said without a trace of irony that denying rubberized playground equipment to religious schools was odious to a free people. And this isn't.
We have about 10 minutes for questions from the audience.
Professor,
Sir, I'm sorry, in the front here, gentleman in the blue shirt.
My recollection is that there were times during the Obama administration when the executive branch was enjoined by district courts from very collective action in what would typically be considered normal administration. During the 8 years of the Obama presidency, was there ever any case of any sort where the Supreme Court of the United States suggested that it had that type of deferential look to the way of executive power?
Who wants to take that?
You know, you could read the Affordable Care Act in some ways as the ultimate result as being you just aren't going to undo the handiwork. That's the signature legislation of this president. In that case, I think that's possible, but it's not right. It's a bit orthogonal to your question, and I don't have a quick example. What he's referring to, though, has to do with nationwide injunctions, and that also was an issue that was presented to the court in Trump versus Hawaii, and that's the question of whether one district court judge sitting in Texas in the case of Obama, or Washington State or Hawaii in the case of President Trump should enter a ruling and enjoin the entire nation. On that one, there's a lot of bipartisan, not complete, but a lot of bipartisan support for the point that a district court judge should not have that level of sweeping nationwide injunctive power. So that's what the case you're referring to, I think, more dealt with than a rebuke to the President Obama compared to President Trump.
Anybody else want to chime in on that question? Other questions? Yes, in the back.
I don't need a mic, I don't think. Can you hear me okay?
If you could wait for the microphone, we would really appreciate it. Thank you so much.
Thank you. For the panel, do you have any thoughts on how this iteration of the treatment of the president's immigration orders affects sanctuary cities, or those cities who are taking it upon themselves to resist without calling themselves sanctuary cities?
In my mind, I see the issues as differently, because the sanctuary cities issue raises more federalism than national security. And so I think that even if the court is, national security is one of those areas where the court is always going to be somewhat deferential to the president. And also foreign affairs, you know, this is directly related to that as well. Whereas sanctuary cities and the federalism issues presented by trying to take money from cities that style themselves as sanctuary cities, there's some jurisprudence that actually limits the federal government's ability to do that. So I think because the issue is different, you might not see the same deference to the president in that context that you see in the context of the travel ban.
I think that's right. You know, denying a local community the money for a Department of Justice grant because they are a so-called sanctuary city. First of all, there's no definition of what a sanctuary city is, for starters. Second, all of the jurisdictions claim that they are complying, in fact, with the underlying statute that's the basis for that part of the executive order. Third problem is insofar as the government seeks to command certain activity on the part of local government, that's the federalism point that she's making. It's called the anti-commandeering principle, which is not waivable. It's something that's an absolute prohibition on the ways in which the Congress or the federal government could order local communities to act. And that litigation's ongoing. It's almost certainly going to reach the United States Supreme Court. It will be resolved differently than this one, but it's unclear. Right now, it's all trending in favor of the sanctuary jurisdictions, the lower court opinions thus far and appellate opinions. But discuss amongst yourselves.
One final question in the back.
As judges this past year, have you seen an increase in universities' use of Title IX, and do they have a good way of enforcing it, in your opinion?
Maybe we could keep the questions related to the subject of the panel that we have. Do you have a question related to the panel?
I missed most of it, so no.
Okay. All right. Maybe you'd like to chime in.
As your criticisms generally relate to the Supreme Court's First Amendment handling of this case, don't those criticisms ignore precedent like Klein-Dienst versus Mandel, and I forget the other case. It starts with a Z, and I can never pronounce it correctly. Zadivus?
Passport case.
Yes. Don't those narrow the universe to which the First Amendment can be applied rather than treating claims disparately? Perhaps you could just address that generally.
Senator Zivotofsky is the other one, and it basically boils down to, is there a domestic establishment clause and a non-domestic establishment clause? And if you want to run it through you have no right to come in, we can keep you out, First Amendment doesn't apply, free speech doesn't apply in the same way, etc., then the answer would be yes, and Klein-Dienst is a case that suggests that that would be the way that the thing might go. Let me invoke what the Cato is to argue in their brief, in which they said, historically, as a matter of original intent, we give due process to pirates offshore, right? And so it may be that to the extent that cases like that make this divide between citizens, non-citizens, here, not here, turf, not, maybe that's the cord that needs to be cut. In the world as it is, but certainly there was a line of cases that they could use to just say snip, snip, entry, stop. Or the Ninth Circuit saying there's something even lower than rational basis when it applies to non-citizens. It's hard to know what gets lower, but sure, that's one frame you could put it in.
Also remember, as to an establishment clause claim, if you think about what the purposes of that particular clause are, it's that our government shall not establish any religion. And that, of course, is reasonably interpreted as shall not disfavor any religion as well. And that is an interest that citizens have, right? In the feeling that their government is not view them as a minority that is second class on the basis of religion. And there is an argument made here in one of the dissenting opinions, and I might be conflating them, but there is an argument made here that that is precisely the case. So Muslim American citizens are legitimately, well, all citizens who want to live in a country where no religion is preferred, Christian and Muslim alike, have a cognizable interest in this litigation, wholly apart from whether it affects and is primarily directed at people who are not citizens.
Plus, in those cases, the free speech, my right to receive ideas might be hobbled by your refusal to allow in someone from elsewhere to talk on those points. And as applied to the travel ban, the notion that there's this bright line between those seeking entry and Americans is, family unification, reunification, the disaster we saw at the airports with respect to travel ban 1. I mean, it's kind of an arbitrary line, I think, too, to not see the implications for American citizens as well as other people lawfully here.
And of course, the deference extended to the executive by cases like the Kleindienst case extends only to cases in which the order is in fact a bona fide order justified by bona fide national security purposes. And of course, the very question and issue in this case is whether the order was in fact issued in good faith and based on the national security purposes which were its ostensible justification, and the plaintiff claimed that it wasn't. That will wrap up our third panel for the day. We have one more panel, and normally I will ask you to wait till the end of the day to thank our panelists, but Professor Tolson has a flight to catch and will be unable to make our final panel of the day, so if you could join me in thanking her. At 3:45 for our final discussion on the legacy of Associate Justice Anthony Kennedy. All right, the few, the proud, the something here, who are sitting it out through the afternoon. Thank you for participating in this conversation here today and for sticking it out with us to the end here. Our final panel of the day, of course, is going to be devoted to the legacy of Anthony M. Kennedy, who was born in 1936 to a prominent Sacramento family. His father, Anthony J. Kennedy, was a prominent Sacramento lawyer. He attended Stanford University and Harvard Law School, where he graduated with honors in 1961. After a career in private practice, he was appointed to the Ninth Circuit Court of Appeals by Gerald Ford in 1975, where he developed a reputation as a careful and moderate conservative judge. From 1965 to 1988, Justice Kennedy also taught, not then Justice Kennedy, Anthony Kennedy, Judge Kennedy, also taught courses in constitutional law at the McGeorge School of Law at the University of the Pacific. In November 1987, Ronald Reagan nominated him to the Supreme Court to replace the retiring Justice Lewis Powell, a moderate conservative who had cast the decisive vote in a number of important cases, including one that law students today still study, Bakke versus Powell, an affirmative action case coming out of the University of California system. Kennedy's nomination followed what was then the most spectacular Supreme Court confirmation battle in American history over Ronald Reagan's first choice for the seat, Robert Bork, an outspoken conservative, a harsh critic of Roe versus Wade, and an early advocate of constitutional originalism, the view that the Constitution must be interpreted in accord with the original intentions of its founders. After this ordeal, in which Bork's nomination was defeated, 58-42, Kennedy sailed through his confirmation hearings. On February 3rd, 1988, the Senate voted unanimously to confirm his appointment as the 104th Justice of the United States Supreme Court. Despite his easy confirmation and his moderate reputation, Kennedy's appointment was widely interpreted as a death knell for Roe versus Wade, the Supreme Court's 1973 decision recognizing a woman's constitutional right to abortion. This was by far the most controversial constitutional issue of the day, and Reagan had twice won election, promising to appoint Supreme Court justices who would reverse this decision. But in 1992, Kennedy and his fellow Reagan appointee, Senator Day O'Connor, of course, originally a citizen of Arizona and a judge on our Court of Appeals here, like Judge Eckerstrom, shocked observers by voting to reaffirm Roe's core holding in a case called Planned Parenthood versus Casey. This decision was enormously significant in itself. Although Kennedy would vote to uphold many abortion restrictions, he would never abandon Roe. But Casey also prefigured three of the central themes of Kennedy's 30-year career on the court, and I'd like to lay these out for you here as a kind of framework for our discussion. The first was Kennedy's elevated, some would argue inflated and grandiose, understanding of the Supreme Court's role in American society. Together with Justice O'Connor and Justice Souter in the joint opinion in Casey, he wrote of the court, "Like the character of an individual, the legitimacy of the court must be earned over time. So indeed must be the character of a nation, of people who aspire to live according to the rule of law. Their belief in themselves as such a people is not readily separable from their understanding of the court invested with the authority to decide their constitutional cases and to speak before all others for their constitutional ideals. So Justice Kennedy's understanding of the Supreme Court's role in American society was not exactly a modest one, for better or for worse. Second, the second key theme of his long career, which is really evident all the way back in the Casey decision, is his reverence for ideals of individual liberty, often expressed in abstract and hortatory, some would say grandiloquent and meaningless language, the uncharitable. Casey contains the most famous example of this tendency, where the joint opinion, nominally co-authored with Justices O'Connor and Justice Souter, but this language seems like pure Kennedy, says, quote, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." Justice Scalia was known to refer to this passage derisively as the sweet mystery of life passage. The third major theme of Kennedy's career, well illustrated by Casey, might be called, with a little poetic license, Justice Kennedy's Whitman-esque temperament. Like Whitman, Justice Kennedy is large and contains multitudes. In particular cases, this aspect of his temperament manifested itself in two related ways. First, for Justice Kennedy, it was a matter of high, some would say self-righteous principle, to give respectful consideration to the weighty interests on both sides of hotly contested cases. Second, and more substantively, Kennedy strove mightily to craft rulings that reconciled, or at least accommodated, apparently contradictory principles without giving either full sway. I think this is what Professor Massaro was referring to earlier during our first panel in connection with the masterpiece Cakeshop case. Planned Parenthood versus Casey is an excellent example of both of these tendencies. While that decision nominally reaffirmed Roe, it also watered down the holding of that case substantially, permitting states wide latitude to limit abortion, so long as they do not impose an undue burden on women's constitutional right to terminate their pregnancies. In this way, Kennedy sought to give simultaneous recognition to a woman's liberty interest in obtaining an abortion, and what he saw as the state's interest in expressing, quote, its profound respect for the life of the unborn. In case after controversial case, Kennedy raised this approach to a high art form, very distinct from the flexible pragmatism and instinct for compromise exhibited by other moderate justices, for example, Justice O'Connor, in recent decades. Kennedy's critics have pilloried this aspect of his jurisprudence for its alleged incoherence, but his defenders could, with some justification, cite F. Scott Fitzgerald's famous observation that, quote, "The test of a first-rate intelligence is the ability to hold two opposed ideas in mind at the same time and still retain the ability to function." Justice Kennedy excelled at holding two opposed ideas in his mind at the same time. Did he still retain the ability to function? I will leave that question to our panelists. But first, I need to tick off a few more of Justice Kennedy's career highlights or lowlights, depending on your point of view. He authored every majority opinion in the Supreme Court's gay rights revolution, starting with Romer versus Evans in 1996, up through Obergefell versus Hodges in 2015. He wrote the majority opinion in a 5-4 decision called Roper versus Simmons, invalidating the juvenile death penalty. He also joined a 6-3 decision invalidating execution of the cognitively disabled. He wrote the majority opinion in Citizens United versus FEC, invalidating federal limits on corporate campaign contributions as a violation of freedom of speech. He joined the majority opinion in Bush versus Gore, bringing Florida's 2000 election recount to a halt and handing the presidency to George W. Bush. He dissented in NFIB versus Sebelius, arguing that the entire Affordable Care Act, known as Obamacare, should be struck down as unconstitutional. Finally, from Justice O'Connor's retirement in 2006 to his own retirement this year, Justice Kennedy was the Supreme Court's median or swing justice, meaning that he fell at the court's ideological midpoint. During this period, 4 justices were more conservative than Kennedy, and 4 justices were more liberal, giving him the decisive vote in most politically charged cases. During this period, there were roughly 50 decisions in which Justice Kennedy joined a liberal majority in a closely decided case, while the next most conservative justice, Chief Justice Roberts, dissented. If Kennedy is replaced by a justice more conservative than he, and more conservative than Roberts, as is widely expected, all of these decisions could, in theory, be vulnerable to reversal. How vulnerable is a question which I want to discuss here with the panelists. But first, as a starting point, I just want to begin by reading a few contrasting assessments of Anthony Kennedy for your reactions. The first is from University of Chicago law professor Eric Posner. Quote, Kennedy stands out from his colleagues because of the frequency with which he votes to strike down statutes and the vapid, flowery language he uses to explain his decisions. Although striking down statutes is hardly new, in the current environment it demands a more muscular justification than Justice Kennedy has delivered. Instead, he delights in gaseous pronouncements. This vacuous, New Age rhetoric turns off people who expect explanations when the judiciary overrules the legislative branch. Professor Posner has obviously inherited his father's, Richard Posner's, sense of tact. Garrett Epps is slightly more charitable, but not much. He describes Anthony Kennedy's mind as, quote, a distant and mysterious country, with its own language and folkways beyond the ken of normal Americans. University of Pennsylvania law professor Mitch Bergman, one of the smartest constitutional law professors working in the country today, has a different take. He sees Justice Kennedy as a praiseworthy example of what Professor Bergman calls principled positivism, by which he means an approach to constitutional law focused on the principles, the high principles, implicit in the American constitutional tradition: federalism, separation of powers, stare decisis, limited government, human dignity, textualism, and so on. Bergman sees these principles, rather than, for example, the constitutional text, at least the constitutional text interpreted in isolation from these principles. He sees these principles as the bedrock of American constitutional law and argues that Kennedy was a faithful and mostly consistent adherent of a view which placed these principles at the center of American constitutional law and tried to derive in good faith outcomes to individual constitutional controversies based on these principles. For these reasons, Bergman dubs Kennedy a, quote, most principled justice. So, to Judge Eckerstrom and Professor Massaro, which of these views of Justice Kennedy's legacy would you say most closely matches your own? And what else stands out to you about Justice Kennedy's very large body of work? We'll start with Judge Eckerstrom.
I think that Justice Kennedy, in terms of the critique of him, is victim to a era of Supreme Court jurisprudence where Supreme Court justices are increasingly defined and now are defined by the modalities of constitutional interpretation that they employ, right? And the theory is, and I think the implication of Eric Posner's critique is that if you don't have a clear guiding principle of interpretation that you apply consistently in every case, that you're essentially simply accommodating your own personal judgments and you're interweaving your own views of what the law should be into your assessments of the law. In other words, implicit in sort of the rise of the notion of originalism as a constraint on judicial behavior and as an enforcer of judicial modesty is the notion that if you don't have a modality of constitutional interpretation or statutory interpretation that abides by some kind of interpretive structure, that therefore you are flawed as a judge and you're going to succumb to what we view as the worst features of a judge, which is insinuating personal views into the matter without principle. And that is a notion I don't think that we should, the notion that you have to be an adherent to either being a living constitutionalist in how you interpret the law as most of the progressive wing of the court would be characterized, or an originalist as the conservative wing of the court would be characterized. He, of course, was independent of any constraining modality of interpretation. But it could be that being eclectic in what tools you use of statutory interpretation, while showing fidelity to what one views as the core principles that the Constitution is designed to vindicate in the context of contemporary society might be superior. So is it at least possible that the Great Gatsby quote, the ability to hold opposing ideas in one's own mind and to still function? Well, from a mechanical standpoint, that's just a feature of good judging, because good judging means you really want to try to put your mind around the perspectives that are offered by both sides. And in, I think, all the cases we talked about today, and certainly exhibited in the Masterpiece Cake case, oftentimes the Supreme Court is required to address issues where there are constitutionally valid theories and constitutionally valid important values at odds with each other, and to come up with a reasoned basis for deciding between the two. And so it seems to me his critiques, at least from the right, are frustrations that he, although appointed by, in lieu of Professor Bork, who had a particular ideology of constitutional interpretation, he has been, I think he can be categorized a little bit as a legal pragmatist in that his opinions and the values he chooses to express through his opinions do, I think, make reference to what is prevailing public opinion and the idea of how important constitutional questions are being resolved in the public domain.
That sounds at least somewhat similar to Professor Berman's defense of Justice Kennedy. Would you agree with Berman's assessment that Kennedy was, at least on the whole, with all acknowledgement of the human failings that any judge is going to suffer from, a most principled justice?
I think he was principled. I think making judgments about who's principled more than any other.
Not the most principled justice, but a most principled justice. A justice who was by and large faithful to his principles as he best understood them.
Yes, I would agree with that assessment.
Professor Massaro.
First, in the Whitman quote, I too am large, I contain donuts. She's trying to keep you awake. F. Posner, okay. This is vacuous New Age rhetoric. All right, was it vacuous New Age rhetoric for him to say that dignity matters for gay people? Was it vacuous New Age rhetoric to write the amazing line when Edie and Thea first longed to be married in the U.S. report, to try to capture what was at stake, or to talk about the children whose lives were affected? The cases often pointed out to excoriate him the most, or where Scalia says, I'd stick my head in a paper bag rather than join the majority opinion in this case, and the gobbledygook, etc. If similarly vacuous lines had been written about Richard Loving and Mildred Jeter when they longed to be married, I'm not sure that that would be been described as vacuous. Or Brandeis writing, men feared witches and they burned women, as a principle of the First Amendment of enduring. He's not the wordsmith that Brandeis was, but just on the point of vacuous New Age rhetoric as an indictment, I'm just not convinced that other efforts on the part of other really important justices are so much clearer, crisper, or more formalistic. How about this one? We have rights that must be fundamental to ordered liberty. Great, thank you for the blueprint. So it's kind of, I get it. Sweet Mystery of Life, I have my fun in the classroom too with that passage, and I get the point, but I'm not sure that the indictment holds. And I've also heard plenty about Justice O'Connor that sounded quite similar. You can't navigate it. There's no theory there, etc. And I think if you flew above her corpus, her body of work, you would see a path that she was cutting. And also, I think that with Justice Kennedy, I thought it was pretty predictable. How's he going to rule in this case? It wasn't often that I had any doubt about it. According to the Posner study, he was 11th most conservative justice in this band of American history. Chief Justice Roberts, in the new arithmetic center, swing justice is regarded as the 5th. So I think there were plenty of principles there. Garrett F. says, Anthony Kennedy's mind is a distant and mysterious country with its own language and folkways beyond the ken of normal Americans. I might prefer to live in that country than one that has really clear marks of turn right here, turn left here, stop. And I think that that goes to something really basic about judges. And I'm not glorifying him or putting him on a pedestal by any means. I mean, I think what the lawyers are saying, here's the point that I understand, try briefing his cases. It's hard work. Not impossible. Citizens United lends itself to a pretty clear statement. The ones that get really hard to brief, and it must bedevil lower court judges, and I think we did see the Masterpiece Cakeshop, are ones in which they're holding, as Professor Coan says, these two ideas at once. And a lot of people can't. A lot of judges can't. A lot of people think it's much easier to navigate in the territory of the known. I know what my answers are, I know what my team is, and I plan that team, and that's it. An area in which he, unsatisfactorily to many, spoke later in his life as a justice has to do with affirmative action and race-conscious measures. And Rita Siegel has written a whole law review article talking about the anti-balkanization principle. And basically it goes something like this. You got our Constitution is colorblind, right? And then on the other side, in order to get past race, we have to take race into account. How are we going to do it, right? And those teams never talk to each other. When he tries to walk down the middle in a case called Seattle School District, what he's doing, he's actually not humiliating either side. He's saying there's something to be said about this, and there's something to be said about this, and I'm going to give you a not very satisfactory answer of what I would do in the middle. But I think that that's the place in which clarity falls apart, because clarity falls apart where the fuzziest lines exist. And I think that because he writes in some of those really important cases about the third way, and doesn't have enough support from other justices to develop, a bright line test, and it's not, it doesn't continue. If the Kennedy conversation were to continue, I think it would become more focused, and worked on. But I think that, it's just that much it feels foreign enough to people. And so I think that what's sad is that I think his legacy will be short-lived, except for the results. I think if you write in that more, vague third way without a clear, this is what I would do instead, it takes a theory to beat a theory. And his wasn't as clear as the ones with which he was competing in some cases. Citizens United, pretty clear, pretty darn clear, right? And it's just these edge cases. And the edge cases, have to do with cases in which he wants to give respect to the religious person in Masterpiece Cakeshop and give dignity to the people who wanted to celebrate their marriage and purchase the cake. So I come down on the side of defending him, despite what is clearly it's not an unfair indictment of his writing style, but I would say that he is principled enough for somebody navigating in the space that he was attempting to navigate. And I think we owe him a lot in introducing the word dignity into the lexicon. Last thing I'll say is I got interested in wisdom. It seems to me that's what we need in judges. And we don't ask the question, we don't have a vocabulary for it, it's this engagement of partisanship. And so I got into the literature. And the literature, it says, be careful if you enter here, you will get lost in the Milky Way of wisdom, right? I think if that's the foreign country, that's where he is. I think that's what he was striving for. I disagreed with him a lot, but I respected what he was trying to do. And these were majority opinions where when you lost, you usually didn't feel like he said, shut up. And there are plenty of opinions written by other justices when they get a hold of the majority that feels like if you're on the other side of the issue, shut up, they explain, the Ringlardner essay on baseball. And so, I find that commendable on the part of him. And I didn't know him, I knew him the least, but I don't know what he was like. I only know him through his opinions. And others have been here. This one I don't know. But I cried when I heard that Justice Scalia died. He'd been in my head for 30 years, right? When I heard that Justice Kennedy retired, my heart sank. And, that stands for something, I think. So that's what I would say about AK. I think he gave a lot to justice.
Thank you. Back in July, Harvard Law professor Jack Goldsmith offered this measured assessment of Kennedy's retirement and its likely impact on the future of the court. There's little doubt that Kennedy's replacement will be conservative, and little doubt, too, that the court will have a conservative bent for the next few years. Beyond that, it is too early to tell. Goldsmith offers a number of reasons for rejecting the alarmism of the left and the triumphalism of the right in response to Kennedy's retirement, but the most important is that Chief Justice Roberts, who will almost certainly be the new swing justice, is, as Goldsmith sees it anyway, a very cautious kind of conservative who cares deeply about restraint, minimalism, and the legitimacy of the Supreme Court as an institution. Goldsmith concludes, a sixth or seventh conservative justice on the court would herald a conservative revolution in a way that Kennedy's replacement does not. Do you agree?
Jack Goldsmith's awesome. I love his measured way of saying your hair shouldn't be on fire. I really respect, I read his blog, I love the way that he thinks about issues, but on this one, let me just say that I hope that that's right, but I don't, there's a line that you have where he says, Roberts cares deeply about restraint, minimalism, and the legitimacy of the Supreme Court as an institution. I agree he cares about the Supreme Court as an institution very much, but I think the incrementalism is not necessarily restraint or minimalism, it's just timing. I think, so putting him in the center of the court, as people predict will happen, I think it may happen slowly, but it's like with, I wish you were still here, the cases involving race and districting and the Voting Rights Act. He lays the things out and then boom. And another case we didn't get to, the Janus case, which has to do with public employee agency fees. The cases were laid out, boom, boom, and then boom. So it's increment, cascade. And so I think that what you're going to see, what we're going to see is the United States Supreme Court, in which the most important debates in the majority are between two types of conservatism. And the cutting edge cases, I think, will relegate the so-called liberal branch of this most conservative court in decades still to maybe more high-pitched dissents, but less of a chance of securing that so-called swing vote if it belongs to Chief Justice John Roberts. That's my prediction. And I think that Roberts is more of the deregulatory vein of conservatism and less transparent in his writing is the social conservatism of an Alito, for example. And there'll be interesting debates about theories of interpretation and so on, but there'll be mostly right-of-center discussions about which should prevail, which voice should be the stronger. Elections have consequences, and they do, and that's happened. It'll only be stronger with a few more. So it really ought to be what would Merrick Garland have done, I think would have been the way of looking at it. That ship sailed. That's my sense of where we're going.
Judge Eckerstrom.
Well, and the sailing of that ship, I think, might influence Justice Roberts to some degree. And there we are in a unique era of public assessments of the institution of the Supreme Court. And I do think that Justice Roberts is likely to be attentive to that. So when I was thinking about this question, my mind turned towards, well, in terms of evaluating whether progressives should be alarmed or whether they should simply be worried. Your mind turns to, well, what constraints are there on Justice Roberts and which ones is he likely to abide by? And so are there constraints on dramatic transformations in the law? And I thought of 4 constraints I listed. The first one is stare decisis. The second one is a concern about institutional respect for the court as a non-partisan arbiter of the rule of law in the eyes of the public. I do think Justice Roberts cares a lot about that too. And I think that's arguably a strong reason why he reluctantly joined the majority in upholding most portions of the Affordable Care Act. At least that is a non-trivial theory about why that happened. Notions of institutional notions of judicial modesty. I do think Justice Roberts would ascribe that as being one of his values. And then lastly, Justice Roberts, to the extent he has a theory of interpretation, would consistency with that theory of interpretation be a constraint. And since the theory of interpretation that he espouses or has articulated, which is a species of originalism, there are a lot of different species of originalism, as I know Professor Massaro could articulate at great length, and I cannot. But that has as one of its core motivating ideologies the theory that it provides judicial constraint, institutional constraint, in a way that living constitutionalism does not. All right, and so these would be the causes of optimism if you're a progressive and you're worried about how dramatically the case law will change in a conservative vein. But I also, we've also all seen in the recent history of the Supreme Court, in particular cases, none of these constraints being controlling. And stare decisis has not been the controlling doctrine when the Supreme Court has thought the issue was important enough. And so you can also very easily see the limitations of all these particular constraints as well. But those are the indexes on which I would try to assess what Justice Roberts will do going forward. I tend to agree with Professor Massaro to the extent she suggested that we're probably looking at more a incremental conservative move, but that in increments, it doesn't take a lot of increments to create dramatic change, ultimately. I do think the most important of the constraints, in Justice Roberts' view, is going to be the constraint on the court as being perceived as a nonpartisan institution. There's been an incredible decline in public opinion of the Supreme Court as a primarily nonpartisan institution to protect the rule of law. Probably with the beginning of more aggressive vetting of Supreme Court justices that you might signal with the caused by Democrats with the beginning of the Bork hearings. But then, of course, tit for tat, the Senate has escalated that over the last 30 or 40 years. And then, of course, the ultimate blow to the notion that we were going to accept a president's appointment so long as they were qualified was the Merrick Garland proceeding, where the Senate claimed partisan authority to simply refuse to consider any nominee of a president of the opposing political party. Whatever the rationalizations were, that is the actual practical effect in terms of public's perceptions of the Supreme Court, and even Mitch McConnell's rationalization of that we're going to let the people decide in the following election, is, of course, partisanizing about as much as you can the notion of how we select judges. And so that has to impact the institution of the Supreme Court in a major way. I think it's in a way that Justice Roberts would be sensitive to. But I do think, because of the precedent that occurred in the Garland, we might characterize as the Garland affair, I think that forever now, Supreme Court justices are going to be selected on utterly partisan grounds. I think it's going to be difficult for presidents who don't command a majority of their same party in the Senate to get any Supreme Court justice appointed. So I think in the future we're going to have 8 justice Supreme Courts at times, if we have any other fatalities. I think it's going to be really difficult when you have a Senate majority that's different than the president to get any judicial appointments done, because if one party were willing to select based on qualifications and the other party exclusively on partisan grounds, that party would be disarming itself. And so it's going to be tit for tat on that. And that's going to choreograph to the American people that the Supreme Court is not a nonpartisan institution that decides based on the rule of law, but actually a very, very partisan institution. Now, and there was a recent, there's been some research done on the behavior of the Supreme Court, and unfortunately, it might validate that theory that it is a heavily partisan institution. Lee Epstein and Eric Posner have done some research on it. They put something in the New York Times about They studied 5-4 opinions, and it was in part a recognition that Justice Kennedy was the only justice that wasn't predictable on the 5-4 questions that had a partisan undertone to them. And they wrote the article worried about and bemoaning the image of the Supreme Court as a neutral arbiter of the rule of law in the context of us needing that institution to be perceived as a neutral arbiter to have a healthy democracy. And we have concerns right now in our country about the future health of our democracy and whether the institutions of our democracy can survive the sort of vicious tribalism and partisanship we have now. The institution of the Supreme Court is one of our, and the rule of law and our judicial branch is one of our bulwarks against that. Where if everybody perceives they get fair treatment in the eyes of the law, then we can have partisan disputes but still feel like we're one country, right? And if we erode that, we are in big, big trouble. And I do think Justice Roberts will be attentive to that. And I think all 9 justices of the Supreme Court are going to be attentive to that. And I think we might see more behavior like Justice Kennedy than you would expect as the Supreme Court's status as a neutral arbiter starts to come into greater question.
Justice O'Connor said when Thurgood Marshall left the court, it changed her. That she was used to hearing Thurgood's voice, and she found herself making different arguments in his absence, and it's a small group, so that's possible. But I'd say, he's got over a decade under his belt. This is not his first term rodeo. He's been the chief for 13 years. And his legacy may already be baked, and so might be his judicial predilections and personality. And I'm not sure anybody thinks that the court is perceived as more of an apolitical institution now than when he took over. I don't blame him for this, but nobody's buying the balls and strikes argument. I don't think that that's all that they do. And I think with the midterm elections, the evangelicals, I think within my own family, they have staked their votes and hearts on what they think will happen with the court. And on the other side, the progressive sickness unto death is rooted in what they think will happen to the courts. And either they're wrong and Goldsmith is right, or it's already happened in the sense of what we think, this preservation of the authority of the court argument. You might say that despite his best efforts as a chief, they've failed. Whether it's his fault or not is another question.
Well, thinking about it from that perspective, how legitimate to a progressive Democrat is going to be a court where Gorsuch were to be the 5th vote, right? Because a fair interpretation of the Constitution is that President Obama was constitutionally entitled to fill that spot. It's the first time in American history that a sitting president who was elected, as distinguished from someone who ascended without election, has ever been denied the opportunity to fill and unable to fill a Supreme Court position. From the standpoint of progressive Americans who voted for President Obama, he was elected for 4 years, and coming with that election was the right to appoint Supreme Court justices. So when you have a big segment of the population who has a threshold level every time they see Justice Gorsuch resolving an opinion in a 5-4, is going to feel that that's not right, that that's unfair, that came as a result of inappropriate partisan machinations, you've got a problem with the legitimacy of the Supreme Court that is going to be very, very difficult to solve going forward, and I think is tragic for the future of our democracy and a lot of the cohesion of our democracy, I guess would be a better way to put it.
But I think the brute truth is not everybody shares that sense. I mean, there are folks who will feel that, I think, over time and will erode, but in the short run, there is not public shame associated with the machinations. It's a sense of celebration and victory. There were wristbands worn by folks who had a lot of objections, probably to things happening under the current administration, but what about Gorsuch, right? That was worth everything. And that's to the tribalism that you were talking about earlier. And then there's institutions have always been corrupt. We've always had these issues, we've always done it. and the slow erosion of norms that's occurring. I don't know that people really care about that. And the people who should have cared more about it, I mean, I watched when Justice Gorsuch went to the White House, and we all watched the news, and somebody allegedly, you know, I don't know if it's fake news, was driving off to throw off the reporters, right? And I thought, what judge would participate in this folly? You know, there should be some things where I think they say, I'm not, you know, Mr. President, I'm not going to participate in that. And during this hearing that we just went through, Gorsuch spoke strongly at his confirmation hearing about preserving the independence of the judiciary. Judge Kavanaugh did not, in the same way that Justice Gorsuch did. So, you know, I think something very serious is happening, but I'm hoping Goldsmith's right. You know, he's brilliant, he's fair-minded, and you know, he's a conservative who gets to the White House and decides the torture memos are no good and speaks truth to power even under those constraints. I just think there's a lot I have a lot of and he's been there in the seat of it. I hope he's right. I hope he's right.
Well, I hesitate to change the subject from this deeply interesting and deeply important set of topics that the two of you have been casting such light on over the past few minutes here. But I think there's probably a lot of interest in the room about the very concrete question of which areas of law are going to change. So let me just give you each a final opportunity in our few remaining minutes here to focus on one area of law that you expect to be significantly affected by Kennedy's departure. We'll start with Judge Eckerstrom.
Okay, and I only choose this one because it's the area where I have the most expertise, and that is in the 8th Amendment law. Justice Kennedy had a profound impact on that, and in a variety of his more recent cases, in cases where in every case Justice Roberts dissented. You have, in the case of oddly named Kennedy versus Louisiana, that was a case where the United States Supreme Court said it violated the 8th Amendment to sentence anybody to death for a crime other than a killing. Justice Kennedy wrote the majority opinion on that. That was 5-4 with Justice Roberts in the dissent. In the case of Graham versus Florida, where the United States Supreme Court decided that you cannot, for a non-homicide offense, give a natural life sentence to a juvenile in the absence of a focused proceeding on the features of their juvenile status. Kennedy wrote that opinion. That was 5-4, Justice Roberts in the dissent. Kennedy also wrote, as Andrew told us, Roper versus Simmons. That was 6-3 because Justice O'Connor actually joined the progressive parts of the court on that. Bear in mind that in the recent 5-4 opinions, the 4 justices had the view, an originalist view of the Constitution, which would reject the prevailing 8th Amendment jurisprudence, which since Trope versus Dulles has been based on the notion of evolving standards of decency, right? Which is a living constitutional interpretive principle, right? A constitutional provision, language in the 8th Amendment can be adapted to the times as evolving notions of what is cruel and unusual are assessed. There are now 4 justices that have the view that that is an inappropriate inquiry, and what we only care about in the 8th Amendment is what was cruel and unusual in the late 18th century. And at that time, you could execute anybody for any crime, and you could execute 8-year-olds for stealing. Would not, in modern society, create many constraints under the 8th Amendment. And so it'll be interesting there to see whether Justice Roberts follows stare decisis, or whether a new conservative 5-justice court utterly transforms the area of 8th Amendment jurisprudence.
Justice Massaro will give you the final word.
Partisan districting, 5th vote gone. Substantive due process, sweet mystery of life. We may track back to Glucksberg, a more crisp history version of that. Establishment clause cases. Coercion hard, not coercion soft, which just means harder and harder and harder to show that there's an establishment clause violation. Smith the free exercise, I think that the court is really poised to expand the free exercise of religion beyond the Smith case, and I'm not sure he would have been a big obstacle to that, but somewhat in the end of affirmative action.
That's all the time we have. Thank you all for coming. Please join me in thanking the